Welcome to the First Department virtual oral argument. The court is now in session. I will begin by calling the calendar. First case on the calendar is People versus Sanchez. Appellant Sanchez gets 3 minutes. The people are submitting. Nieves versus BHVI 4. Appellant BHV gets 5 minutes and 2 in rebuttal. Respondent Nieves gets 5 minutes. R. Kiosha is submitted. VPC projects, appellant VPC projects is allotted 6 minutes and 2 in rebuttal. Goldenbuck is assigned 6 minutes. Diaz Pascal is submitted. People versus Pilgrim is submitted. Mallorca versus 75 Plaza and Old State Interior. Appellant Mallorca gets 6 minutes and 2 in rebuttal. Respondents 75 Plaza and Old Interior get 5 minutes each. USA Recycling. Appellant USA gets 5 minutes and 2 in rebuttal. Respondent Baldwin gets 5 minutes. People versus Martinez is submitted. Casita versus Glazer. Glazer Maplewood appellant gets 6 minutes and 2 in rebuttal. Casita gets 6 minutes. Ibarrondo is submitted. New York Times versus the City of New York. Appellant City gets 6 minutes and 2 in rebuttal. New York Times receives 6 minutes. Luciano Mahoney versus Rossman. Appellant Luciano Mahoney receives 5 minutes and 1 in rebuttal. Respondents Rossman, who I understand will be arguing by phone, gets 5 minutes. Valley National Bank versus Page One. Appellant Page One gets 4 minutes and 1 in rebuttal. Valley National gets 4 minutes. Portillo versus DRMBRE. DRMBRE gets 6 minutes and 2 in rebuttal. Portillo gets 6 minutes. Gagliano versus Fire Department. Petitioner Gagliano gets 5 minutes and 1 in rebuttal. New York Fire Department gets 5 minutes. Rodriguez versus Beal. Beal gets 4 minutes and 1 in rebuttal. Rodriguez gets 4 minutes. Jimenez versus City of New York is submitted. Or versus Young is submitted. First case on the calendar is People versus Sanchez, who gets 3 minutes.
May I proceed?
You may proceed.
Thank you, and may it please the court. Nicholas Raskin from the Legal Aid Society on behalf of Pilar Sanchez. This court should reduce Ms. Sanchez's sentence from the maximum term of probation because she was arrested for the first time at 55 years old for trying to financially support her son as he battled cancer. Her own poor physical health kept her out of work, and so money was tight. Ms. Sanchez had been seeking and receiving mental health treatment on her own for a decade. She was living with her long-term partner of 18 years, and she was the mother to 2 grown children. All of these circumstances show Ms. Sanchez to be a caring mother who made a one-time mistake. But after her guilty plea, Ms. Sanchez was sentenced to the maximum term of probation. Her sentence was excessive, and this court should reduce it in the interest of justice. Ms. Sanchez's circumstances made clear.
Was there a rationale? I mean, did the court explain why she was maxed out on the probation, on the 5-year probation, rather than at the minimum of 3 years, particularly for a first-time offender?
There was no explanation on the record, Your Honor, for the 5-year probation term. and the circumstances made clear that a shorter term of probation would have been appropriate. Probation serves a rehabilitative purpose, and it does so through supervision. But Ms. Sanchez didn't need this supervision for 5 years. She didn't have a history of breaking the law and had spent 3 decades as an adult living in New York City without ever getting arrested. And for the 10 years before her arrest, Ms. Sanchez continually received mental health treatment without formal supervision. And in this case, the pre-sentence report even recommended that Ms. Sanchez continue receiving the same mental health treatment that she had already been getting on her own, which showed that she already had the tools that she needed to rehabilitate.
How long has she been on probation now?
She's been on probation for almost 4 years. Her sentence was executed in 2017 in April. And the legislature amended the penal law to allow for 3, 4, or 5 year probation terms, even for a Class B felony like Penal Law 22039, which is the statute that Ms. Sanchez pleaded to. And the legislature's decision reflects the reality that probation terms can be burdensome. And for some people convicted of an offense like Penal Law 22039, the 3-year term of probation is appropriate and a 5-year term would be excessive. And Ms. Sanchez is exactly that kind of person.
Counsel, do you know how often she reports to probation right now?
I don't know how often she reports to probation, but the record doesn't show any violations or any issues with probation.
Okay.
The record makes clear that this was a one-time mistake, and it was an act of desperation to help a son who was fighting cancer. Ms. Sanchez accepted responsibility for her mistake, and she pleaded guilty less than a year after her arrest. Ms. Sanchez didn't need 5 years of probation to rehabilitate.
So you're asking us for a reduction to 3 years?
Yes, Judge. But since she's
already served 4.
She's coming close to serving 4 years. The 3-year sentence would have been appropriate, but reducing it to 4 years would mean that her term would almost be over.
Okay. Thank you. Thank you very much, Mr. Ruskin.
Thank you.
Nieves versus BHV 4.
Hi, this is Andrew Shaw. I just want to make sure that you can hear me.
I can hear you.
Okay, if I may begin?
You may.
Thank you, Your Honor. Good afternoon. May it please the court. I represent the appellant BNH the Fourth LLC, who is the owner and landlord of 2285 Sedgwick Avenue in the Bronx, as well as the managing agent Wilder Realty. This appeal stems from a slip and fall on rainwater that came in from an open window that had allegedly accumulated on the 5th floor stairway landing in the apartment where the respondent had located in the Bronx.
Counsel, this is your motion, is it not?
Correct.
So
no,
you
this was my motion and it was
denied.
denied.
It's your motion, so you have the burden here. Have you met your burden where you can't demonstrate, or I don't know, maybe you have, what your procedures and practices were for inspecting or cleaning or?
May I, Your Honor?
Yeah.
Before I get to that issue, I think there were a couple of other important issues. Number one, under First Department case law, this department has held that wet areas on a walking surface such as a floor landing doesn't constitute a hazardous condition. The plaintiff, the respondent in this case, had already admitted that the sole cause of this accident was water that she slipped on.
It was water from, first of all, you might like to answer the question that one of us asks, and I asked you a direct question. You might want to answer it before going to the thing you think is more important. But beyond that, I think there was an open window here that was left open deliberately. Is that right?
Your Honor, I don't think it was left open deliberately. My client, who is has the on-site,
even if it wasn't.
Yeah, my client has an on-site super who lives in the building, Your Honor. He testified and also swore in affidavits that he was in that building every day. He looked at the stairwells every day. He mopped.
Counsel, this is Judge Singh. Hold on a second. Is that precisely what what Super testified to at the EBT? Or is that what was stated in his affidavit in support of a motion for summary judgment, a affidavit presumably prepared with the aid of counsel?
We had submitted both, Your Honor. There was first an affidavit, and there was also his deposition testimony. And what he did say,
he said he generally mopped once or twice. Is that what
correct?
he said?
Correct. But what he also said, Your Honor, was that he lives in the building. He goes in the hallway. He goes in these stairwells every single day. So I would submit, Your Honor.
But he didn't. He testified as to when the last time was that he inspected the window.
There is no precise time as to when the last time he looked at that window.
Do you
But
think that based on First Department precedent that that's your burden to show?
I understand, Your Honor, but the only time that that we were told about this issue was about a month before. And also, we don't know how long the wet condition was there or how long it had rained. So how are we supposed to say when?
Counsel, the assertion, as I understand it from the record, is that the plaintiff's theory of the case, so to speak, is that it was a recurring condition, that the plaintiff had on a number of occasions said to the super, complaining about the window being left open, et cetera, et cetera. Isn't even assuming you didn't answer my colleague's question as to whether or not you made out a prima facie, but even assuming you made it out, isn't there an issue of fact based on the competing testimony of the plaintiff and the super?
No, Your Honor, because what the plaintiff testified to was that she had told the super one time about a month before and one time after the incident, although she testified that that there was rain there on multiple occasions, she never told him about it. She never told the landlord about it. And also her son, who put in a written statement, who is a unbiased third party, said, we never told the appellants about this issue. So the only notice.
Actually, I thought that her testimony in her EBT was that she specifically testified that she had complained to the super in person before her accident about the open window in the stairwell, and that's record at 107 and 109. Why isn't that sufficient notice to you that whenever it rains, you need to check that window?
Because, Your Honor, if this is told to us 1 month before and we're not told any other time before that.
How many times do you have to be told in order for us to decide the issue as a matter of law?
My client had testified that anytime he saw a window open, he closed it.
Well, but isn't what the plaintiff is saying here is that it was a recurrent condition, that window was continuously left open and that water was coming in. So she told the super in person that was a condition at that premises and that was something that they should be looking for.
See, in order for that issue to be decided as a matter of law, had you had testimony from the super saying, oh no, I inspected that window when it started raining an hour or two before and there was no rain, then we have an issue to discuss as to whether that's sufficient or not. But the fact that there is no evidence with respect to when you last inspected the window, that's dispositive.
Well, I would differ, Your Honor, and the reason I would say that is because he says he was in those stairwells every single day.
Which was, counsel, my first question to you, which you found unimportant. You thought there were other things more important to answer. That's why it's a good idea to listen to the questions that are asked and answer them first.
I understand, unless there are any other questions, Your Honors.
I think we're good, Mrs. Shaw. Thank you.
Good afternoon, Your Honors. Jillian Rosen for the respondent plaintiff. It's our position that the defendant didn't establish a prima facie case. The affidavit of Loshaj doesn't establish the last time he was inspected the stairs, doesn't address the last time he mopped it, doesn't establish any janitorial.
Counsel, this is Judge Singh. Did Mr. Loshaj address those issues in the EBT?
No, in his deposition, he actually testified that when it rains, this is at 327 of the record. He says he's in the stairwell every day, but he doesn't testify as to what he does every day. He says he mops it once or twice a week. We have no evidence as to when he last mopped it. And at 327 of the record, he actually testified that he has seen the window open and that he's closed it because he doesn't want things like flowers, flies, and mosquitoes to come in, and that when it rains, he actually goes and checks the windows. This is at 327 of the record, but he doesn't indicate either in his deposition transcript or in his subsequent affidavit when anything was last inspected and last cleaned and last mopped. And actually just recently, Judge Renwick and Mendez, you sat on the Gartenberg case, and this is actually 133 New York sub 3rd 820. This was just in December, where a defendant was denied summary judgment because they didn't submit evidence as to when the bathroom was last cleaned and inspected. So I think that this department is very clear by numerous cases that's in our brief that you have to establish the last time. In order to establish a lack of constructive notice, you need to establish the last time that the area was inspected or cleaned prior to the accident. And with regard to my adversary's position that we need to establish how long that the condition's been in effect. Just recently in White, this court held that because the defendant didn't meet their burden, the burden doesn't shift to the plaintiff to demonstrate how long the condition exists. And that's White against MP 40 at 187 AD 3rd 561. So on this record, the defendant did not meet their burden, and we ask this court to affirm.
Yeah, thank you, Ms. Rosen.
Thank you.
Mr. Shaw, we'll give you a minute.
Just briefly, Your Honor. With regard to the issue of the inspections that Justice Renwick had talked about, in his affidavit, he did say as part of his duties, he inspected the building daily and he addressed tenant complaints. That's at 340 in the record. Also, as this on-site building super, he was in the building stairwell daily.
Yes,
sorry?
Yes, you're correct, but that is very general. That is a very general expression of what he says he did. He was not specific. There was no log. There was nothing in writing. There's nothing specific for us to know what he did on that day or what he did as, anyway.
If I may just respond very briefly?
You may.
Your Honor, the only response that I would give you in terms that I do acknowledge we don't have a log, obviously, but he does say in this affidavit and in his in his affidavit that he was in the building stairwell daily. That means every other day. That doesn't mean something he did occasionally, once in a while. This is what he did each and every day. That's my response.
Thank you, Mr. Shaw.
Thank you, Justice.
Thank you both.
Thank you.
VPC projects.
May it please this honorable court. My name is Dan Abrams. I represent the Appellant VPC Projects LLC. This is a legal malpractice case arising out of allegedly negligent advice rendered about an insurance policy. The trial court granted summary judgment, finding that the law firm performed merely a ministerial act when it transmitted the insurance policy to the insurance broker. In our view, the trial court sidestepped evidence which showed that the law firm told VPC and told VPC's principal and told the father principal, quote, "You are not covered,"
Counselor, this is Judge
close quote.
Counselor, let's assume
yes.
for argument's sake that you're correct on that issue and that arguably it's within the scope of the retainer based on what you're saying. How do you connect the law firm's actions to ultimately the damages that you're seeking in this case?
Well, I guess that there are two issues there. There's causation and there's damages. On causation, my VPC's principal has testified that she was unwilling to keep the business open in the face of what she was led to believe was a $10 million uninsured lawsuit. And under the circumstances
and when was
created by...
When did, just let me stop you there. Chronologically, when did that happen? Because in February, the father writes to the lawyer saying, we're throwing in the towel, right? So when, what you're referring to, when does that occur? Does that occur some months afterwards, or are you saying it was before that?
No, the testimony in the record reflects that advice was initially given in late January.
But the advice that you're speaking of, at least looking at the record, it indicates that, the daughter asked Jaffe in an email, "Does this mean I'm covered?" And Jaffe responds, "No, not at all, probably not, but we will give it a shot just in case." So that to me suggests that she's saying it's not a great case, but we're going to give it everything we've got. That doesn't sound like she's saying your answer is no, there's no way you're getting coverage. It wasn't a definitive answer at that point because it had only been, I think this was in the beginning of January, January 6th. It was the first time that the policy had been, that the broker was getting the information on this particular policy.
Correct, Your Honor. That's consistent with my understanding. That email Your Honor is referring to was, I believe, January 5th. The advice we're alleging is negligent took place in late January, and the throwing in the towel was in February. So it is consistent time.
Where in the record is that advice? Just to be clear, where is that advice that says, no, you don't have a case, or something to the effect that was definitive about the information that was given?
Just to be clear, Your Honor, you're asking where in the record what was...
Well, you're saying that Jaffe gave information that led the daughter, your client, to believe that they did not have any case. They weren't going to get anything from the insurance company. Is that not what you're saying?
Well, I just want to... The case against the other side is one thing. What the law firm told them is they're not covered by insurance.
When did that happen? That's what we want to know.
When?
The testimony was that it happened in late January.
Do you have something in writing as to that?
There's testimony from both Robert and Heather in terms of the advice that was given. I think if you looked at Heather Millstone's affidavit, which is in the record 994 to 998, it goes into some detail about that.
So this was a verbal communication?
Yeah.
Between the attorneys and the daughter and the father.
That's correct. And I don't know if the record is unclear as to whether the daughter and the father were on the phone at the very first time the daughter heard it, but there is repeated evidence in the record, 873, 890, 524, 525, 755, 539, 540.
That was their testimony regarding a conversation that they had with the attorney wherein the attorney said, you're not covered. Plain and simple, right?
That's correct, Your Honor.
But isn't that totally...
Mr. Abrams, can you address yourself to the issue of damages that was asked by Justice Singh? How was the malpractice the proximate cause of the damages that was sustained? You were never making a profit.
That's correct, and we're not seeking lost profits in this case. What we're seeking are sunk costs, which is the same theory that the law firm was actually seeking in the underlying case, which is that if you...
Well, what evidence, what non-speculative evidence is there that you would have realized some of that cost had you remain open, but for the malpractice?
Well, these were essentially sunk costs. When you say realize the cost, if you have to shut a business down.
You invested $1 million in the bar, right? The bar was not making a profit. What makes you believe that anything, assuming that you were given incorrect advice or improper advice, what made you believe that you would have recovered the $1 million you invested? Isn't that speculative?
Well, it's not about recovering. You know, if you have and the business is proceeding apace, you have an opportunity to recoup your investment in the business. And
yeah, but you were bleeding. But you were bleeding. Isn't that what the daughter, the plaintiff herself said?
Her father said hemorrhaging.
Their father hemorrhaging money. So how are you going to recoup anything when you're losing money every day? Well,
the testimony was that because of the lawsuit, yes, they were losing money at the time. Is they had to close. They couldn't serve alcohol. And it certainly interfered with the business. But I mean, it's not about whether they made a profit at the end. It's simply about they have sunk costs into the investment. And we cited to the Callista case where we say there's a distinction between lost profit damages, which we concede are not recoverable, and sunk costs, which we believe are recoverable.
Okay. Thank you, Mr. Abrams.
Thank you.
Let me hear from respondent.
Yes, sir. Can you hear me?
We can hear you.
Oh, I'm sorry, I just didn't pop up. John Somoza, counsel for Golenbach, Heisman, Asner, Bell, and Pesker, which I'll use Golenbach just to make it easier. Your honors have all made excellent points, which we have raised in the case as to the speculative nature.
So I'm sorry, this is Judge Singh. So your adversary essentially says is that he's not seeking lost profits, but monies were invested and he's entitled to get those investments back. Why are those, in your view, speculative damages?
Exactly for the reason one of the justices said. You invest $1 million in a building, you don't even own it. You're just investing it with the hope that the business will profit and go on, and at some point that will benefit you. You'll be able to recoup that. So if the business is hemorrhaging cash, there's no money, we're going to throw in the towel, all the language is contemporaneously stated by the VPC personnel as to how the business was going in the tank. It's quite correct that that business will never have legs. It would be totally speculative that this business would have enough legs to go long enough to recoup that initial investment of the $1 million. It was a boat dead in the water.
So basically, regardless of whether or not they received erroneous advice, that business was going under anyway. That's your argument? That
is one of the arguments, but we don't agree that we provided speculative advice.
Right.
There are two instances which VPC seeks to manufacture the rendering of advice. The first was when Ms. Jaffe, the litigation attorney, basically asked Heather Millstone if she might have any insurance that might cover the claim. She said she did. Remember, Darby v. Darby, if you take it to its extracted interpretation, may impose such a duty or not, but she fully complied with that concept. She said, do you have any insurance? She got the policy, she took it, she got the name of the insurance broker, which VPC had worked with for years with this company, took the summons and complaint, sent it to the insurance agent. The insurance agent and Ms. Jaffe copied Ms. Heather on all these communications. I believe Robert was communicated on as well. The insurance agent said, I'm sending it to the insurance company as a tender of the claim. We'll keep you posted. And their latch on it appears to be, as Justice Renwick said, that Ms. Jaffe, in response to a question, because Heather said, as a result of this tender, does this mean I'm covered? And Betsy said, no, maybe not, but we're going to give it a shot. That is being elevated to the level of insurance coverage advice.
Is counsel correct that your client made subsequent statements, or at least the daughter reported subsequent statements with respect to insurance? Well, or is that the only thing in the cover in the record?
That's I'm not sure about the last part of your question, sir. The allegation that VPC has now gone to, obviously seeing the frailty of the first argument that they make, that this sending of the complaint to the agent somehow made us accept it and posed a duty upon us to render coverage advice. The second is a phone call which allegedly took place in January 2012, late January 2012, maybe February. Maybe Robert was on the call, maybe he wasn't. Can't tell you exactly what she said or not, but it was words to the effect of, if you look at the deposition testimony, the pleadings, even the summons and complaint, the most that they are alleging she said is that the insurance company declined coverage. That's not rendering insurance coverage advice. She didn't say, I've reviewed the policy, I made a determination, there's no coverage, there's no chance. Now, we're not saying she said that, because we believe that the evidence is highly inconclusive that such a communication, in fact, took place. And if you look at the record in the citations, it's all over the board. But even if you don't even have to get there, if you just go to what the allegations are in the complaint, it's alleged that VPC was told that the insurance company said there's no coverage. Other
Thank you.
allegations throughout say the same thing. There's no, in fact, Heather overtly stated that VPC never rendered a coverage opinion as to whether there was coverage or not. So clearly, out of their own mouth, they're saying they didn't render coverage advice. At worst, if you accept, and we don't accept the fact that this communication took place in the way it's now being asserted, that any opinion as to what, any fact as to what the insurance company said or didn't say took place. But even if you take that as, okay, well, let's not really hang our hat on that. What she said was not legal advice. It wasn't an assumption of a duty for the law firm to then be involved in insurance coverage determination. Now, going back to the proximate cause issue.
Well, your time has run out, Mr. Somoza. I'll give you 30 seconds to.
I'll go very quickly. The nail in the coffin is Robert, who was the father who really ran the operation of the lawsuit. He sent a demand letter, which I'm sure you're familiar with from the record, because you seem like a demand letter where he got into the law firm's face and said, "Hey, you guys dropped the ball." He also said the agent dropped the ball, by the way, and he said, "You guys dropped the ball, and you owe me the legal fees that I didn't get to recoup." No mention is made. This is 2 years after VPC closed. No mention is made whatsoever that the damages that he thinks the law firm is responsible for includes the closing of VPC. So this is after what, 2 years, 4 years after the closing. This lawsuit came up, and that was the first time that we start to see that kind of an allegation.
Thank you.
Thank you. I appreciate the extension of time.
Not a problem. Mr. Abrams, you get a couple of minutes.
Thank you, Your Honor. On the very last point he made, Robert is not VPC. Robert wrote a letter 2 years after the fact on his own, with his own issues pertaining to Golenbach. That letter is hardly dispositive of this case. Again,
Counsel?
yes, he was.
Sorry to interrupt. Wasn't he?
Yes, he was.
Obviously, there is some relevance to what he says then, right? He's been paying the bar's bills.
Sure, it is. A jury can sort that out, but again, he's not the bar. He's not sitting there, in the cafe running the business, and he was not. He was writing that letter in his own capacity. Once again, contrary to counsel's argument, the record is very clear that there is an issue of fact. If an attorney says you are not covered, that is legal advice. It doesn't matter whether the attorney reviewed the policy or not. Sometimes you get bad advice because the attorney misreads the policy. Maybe there was a miscommunication with the broker. Whatever the reason for the misadvice, there was erroneous advice with respect to the policy. On the damages issue, I would just point out that VPC's sales doubled in the year prior to the.
Did it ever make a profit?
Prior to the lawsuit, excuse me?
Did it ever make a profit? I mean, the sales doubled, but did it ever make a profit?
No, Your Honor. But I would also point out that on page 30 of
Yeah.
Froze.
Yeah, you froze, Mr. Abrams. So I'll give you an extra 30 seconds if you can recoup.
I think he's gone.
Yeah. Okay.
I think we understood his point.
Yeah, we understand his argument. So thank you both. We'll go to the next case. Thank you, Mr. Abrams. Thank you, Mr. Somoza.
Be safe.
Thank you.
Mayorga versus 75 Plaza.
Good afternoon again, Your Honors. Jillian Rosen for the plaintiff appellant in this case.
Wait a second. Don't we have Diaz-Pascal versus Pereira?
No, that's omitted, Justice Renwick.
Okay.
Right.
Go ahead,
Okay.
Ms. Rosen.
Okay, thank you. This case, it's our position in this case, despite the fact that the plaintiff was the only deponent, that plaintiff established the prima facie case under 240 and 241-6.
Ms. Rosen,
Yes.
my question is a simple one. I mean, clearly the rope was inadequate to secure the 200-pound damper, right? So
Right.
Where in the record is there the availability or evidence of the availability of another device?
Well, there isn't, which is to our point that plaintiff testified that he was provided with a man lift and that he had to improvise and really make this makeshift pulley system in order to secure the damper to the temporary, if you look at the photographs, if you're able to look at the photographs, it starts at 259 to 261. It really shows you what the damper looks like.
Mm-hmm.
And he was unable to secure it. So he had to take the rope. If you look at 260, you see a hole that's at the top of the damper, which is on the right side of the photograph. And he had to take the rope and tie a square knot through it and lean it against the beam in order to secure it while he tried to lower it. And he was given no adequate device to lower it. And to your point, but to take it a step further, is he tried to lower it with the man lift and he couldn't lower it. So he got off the man lift and realized that there were 4 welds underneath. If you look at page 260 of the record, I'm sorry, 259 of the record, you'll see that bottom horizontal bar. That's where the brass welds were underneath those brass welds were underneath that bottom bar. And he realized that those welds hadn't come off, and that's why he couldn't reduce.
So they were still holding the damper.
Correct. And what he did was he couldn't put the man lift underneath the doorway. It didn't fit. So he had to stand underneath and use a crowbar or a blowtorch. It doesn't make a difference. The defendant thinks there's a distinction there, but there isn't. It's an inadequate safety device, and he had to be, and he testified to this. It's consistent in his affidavit at 59 of the record that he had to stand underneath it and remove it. And he had his coworker, who we know is not a safety device under the labor law, holding the rope and making it taut while he removed that last brass so that it would not fall. Then he screamed and said, move out of the way, and he couldn't in time. So it's our position on this record that we establish our prima facie case, and if you shift it to the defendant, they did not establish that any adequate safety devices were provided.
Well, but wouldn't the defendants argue that the damper is part of the permanent structure, so 240 Prens 1 doesn't even apply? How do you respond to that?
Well, it's our position that the damper isn't a part of the permanent structure. It's not like it's a ceiling or an interior staircase, but even this court is held in Gorey that even when you have a permanent structure, it doesn't remove it from the ambit of 240 subsection 1 if adequate safety devices weren't provided. I mean, this wasn't
demolition, right?
Yes, it wasn't right. So, but the damper wasn't to be demolished at this point. It was to be removed.
Removed from the wall.
Removed from the top of the door.
From the top of the
From the top of the door. So our position is that demolition workers shouldn't, there shouldn't be an exclusion for demolition workers in the event that they're doing demolition. We understand that the object was to take it down, but the object wasn't to demolish that at that particular time. So that would be my response to you, Judge Singh, on that. And I can wait for reply with regard to 241-6. Okay.
Thank you, Ms. Rosen.
Thank you.
Okay, let me hear from respondents.
Good afternoon, Your Honors. May it please the court. My name is Nick Diamantis. We represent the defendants, 75 Plaza LLC, RXR Realty LLC, and RXR Construction Development LLC. Just going to the points which were raised by counsel, the fact that the allegation is made that the inadequate safety devices weren't provided, that's a one-sided story. At the time that the motion was made, plaintiff's deposition hadn't even been completed. It was only partly completed, and plaintiff's counsel moved for summary judgment. There's been no deposition testimony, even to this day, from Allstate, who was a subcontractor that was hired to do this work, or the plaintiff's employer, which is still in dispute at this time. So all we have is the plaintiff's testimony in this case that he wasn't provided with adequate safety devices, and that's it. We don't have any other testimony from relevant parties that are parties to this action that could provide information.
Well, counsel, couldn't you have obtained affidavits from these various individuals with respect to what their version was as to what happened?
Well, they're represented by counsel, Judge, so I couldn't reach out to them and get affidavits because they're adverse parties and they are represented by counsel. So that's not something that I could have gotten on my own or through an investigator. I was hoping to do that through deposition testimony, and I think with deposition testimony, we will have these answers and this testimony. But because they are represented by counsel, that's something that we could not have done at the time that this motion was made. So that was one of the hindrances at that time. But I think that's something that could be.
So what would have been the discovery that you think you would have gotten to defeat summary judgment?
Well, there has been testimony that devices were provided to him. He's already testified that not only was a man lift provided, there was also a scaffold provided, as well as ladders, including other safety devices. So I want to know, and I'm trying to find out, is that it? Were there other safety devices? Because right now, all we have is the plaintiff's testimony. His employer or Allstate, depending whether Allstate's their employer or not, they can attest as to what was provided at the site. And if there were devices that would have assisted him in taking down the stamper.
Or you could have obtained information with respect to what other devices are there available to perform the task that he's being assigned, right?
Correct. And that's the point of further discovery. And I think that's why the judge properly denied this motion, because there's so much outstanding discovery in this case. And you can't grant the motion for summary judgment just on one side of the story. So I think that's why the judge properly denied the motion for summary judgment in the lower court, because it's grossly premature at this point. And more discovery is needed to get these answers, which are relevant points, because if there were devices provided to them, if Mr. Mayorga knew about them and just failed to use them.
I'm sorry, whose responsibility is it to provide these devices? I mean, he's given an assignment. He says he asks for a second person to assist, someone who is trained or whatever. He's told, no, that person doesn't exist. The scissor scaffold, scissor ladder, or however it's referred to, is there. How many is he responsible for going and getting, trying each one of the 4 different types of scaffolds that might be available? He's able to reach it with this scaffold. I mean, isn't that the responsibility of the owner and the GC to ensure that he has access? He's already been denied a person to assist him.
Our position is that responsibility lies with his employer. Oftentimes at these job sites, the means and methods on how this stuff is done is handled by the plaintiff's employer and the subcontractor that's hired to do this work. Although we have overall safety responsibilities as a general contractor, the means and methods on how it's done is done by and performed by his employer. So it would be his employer's responsibility to provide the proper equipment to properly perform this task. And that's pursuant to contract with his employer that these materials are provided. And in addition, you made reference to the affidavit where the plaintiff said that he asked for other individuals to help him. That's contradictory, and that leads to another issue of fact in his case. In his affidavit, which he submitted in support of his motion for summary judgment, he made that attestation that he asked for more people to help him. But when I deposed him, he said that he didn't ask anybody for any additional help. So there's a lot of contradictions here, which leads to the overlying fact in this case that there are significant issues of fact that have yet to be determined and yet to be flushed out. And that's why we believe, and it is our opinion, that the court was correct in denying the plaintiff's motion at this time.
Thank you, Mr. Diamantis.
May it please the court, my name is Anthony Broccolo. I represent Allstate Interior Demolition. Mr. Diamantis hit most of the things that I would have mentioned. I just wanted to point out that.
So I'm sorry. So this is Judge Singh. So you gave a reasonable explanation saying that, well, I couldn't go to your employees to get affidavits. Couldn't you have gotten the information with respect to other safety devices, et cetera, from your clients?
So our client, and this is what it's in the record, is not the employer. There's payroll records and other documents in the records that demonstrate that the plaintiff was employed by United, which was a subcontractor. Our client is a few guys who get contracts and then subcontract, most often United, to actually do the work. So United, we don't have access to. They never answered. A action was brought against them by us, but they never answered. We never had access to them. So
aren't you you're the general, I'm sorry, you're the...
We're a subcontractor, and then we had a sub.
But you're part of the demolition.
Yeah,
so you don't know. So you need to rely on plaintiff or anybody else to determine what the adequate device is to remove a 200-pound damper from a wall.
No, we don't need to rely on them to determine what's adequate, but whether or not it was provided to him, we need to find out from the employer who was there with him and offering him the items. And his testimony was that it was offered.
Isn't it your responsibility? I mean, you're the equivalent of a GC, aren't you? There's the owner, there's a GC.
There's a GC on the case. There's a GC on the case represented by Mr. DeMontis. We're just a sub for the demolition.
Mm-hmm.
And
so you take instructions from Mr. Diamante's client.
Yeah, and then we
I mean, somebody other than plaintiff has to know what the safety device, what the appropriate safety device is to remove that damper. That's not within the plaintiff's knowledge.
But
and it's not only with, I understand that your argument is that, well, it was the plaintiff's employer, but it's the responsibility of the owner and, to know what devices there are as well. I mean, ultimately, that's what strict liability is against the owner and the, go ahead.
His testimony was that he was provided those things, and then his affidavit contradicted that, which is a textbook question of fact. He contradicted himself on crowbar versus a torch, on devices or no devices, on whether or not he asked for people to be provided. He just said,
I don't know whether crowbar versus a torch makes a difference. If you're underneath something and, whether it's a crowbar or a torch, there's going to be a moment where it's not connected anymore and it doesn't tell you, so it falls. But in terms of the devices, the other devices, I thought, I could be wrong, that he said there were other devices. He had the scissor lift.
Yeah, he had the man lift, but he also testified that there was ladders, scaffolds, pipe scaffolds, that there were other devices there. And he did make the choice to try something else. And the choice he made was to stand underneath the damper and to use a rope rather than pursue these other things. He did pursue another device. He just
was he offered or instructed to use other devices or methods to remove the damper?
I don't believe he was instructed to try different things, because he encountered his issue and then chose himself to go use the rope. He didn't ask. He didn't consult with anyone.
Whose burden was it was it your responsibility to give him the instructions as to the methods to be used and the devices to be used, rather than plaintiff having to figure out for himself what he needed to do to remove the damper?
I mean, he was given an adequate device to remove the damper, except unbeknownst to anyone, there was welds behind it.
Right.
No one knew
it clearly wasn't adequate. The rope wasn't adequate because he broke, right?
But the rope was let go by, I believe, by the Mr. Pepitone, which is also an issue. We never had the chance to depose him.
Well, that's what happens when, even with the assistance of a rope, 200 pounds is 200 pounds of dead weight. That's a lot of weight.
Can't deny that.
Okay. Thank you, Mr. Mercolo. Let me hear from Ms. Rosen.
Yes, just a couple quick things. The first thing is on page 201 of the record. The defense attorney stated, I've completed liability section at the deposition. There's nothing further. If there's any depositions to be held, it would be on damages. All of plaintiff's testimony has been stated and has been held according to the defendant's own admission in the transcript. That's number one. And number two, there's nothing contradictory to his deposition and his affidavit. At 199 of the record, he did testify. This is the equipment that was involved: the scissor lift, the torch, the crowbar, but it wasn't adequate. There is no evidence on this record that he was instructed to use something else that he didn't use for no good reason, or that he was told not to use what he was given. And of course the onus is on the defendant to get it, but it certainly doesn't place the the onus on the plaintiff to go fetch another safety device. The cases are legion. I don't have to name them. You're on all of the cases that I have in my brief, basically. Yeah. So as to that degree, our position is our prima facie case has been made. With regard to 241-6, I won't belabor the issue. It's in my brief, but under the two sections that we cite, we feel it's supported, it's specific enough, it's applicable to the facts, and that there is no question of fact that we should have summary judgment on 241-6 as well. If you have no other questions, I'll rest on my brief.
Thank you, Ms. Rosen.
Thank
you, Mr. Bracolo and Diamantes.
Thank you. Have a good day.
Thank you. Have a good day.
U.S. Recycling.
Yes, Your Honor. May it please the court, Anthony Centone on behalf of the plaintiff appellant, USA Recycling. Your Honor, the case involves a action for specific performance in which it is the appellant's position that summary judgment was improperly
The specific
granted.
Performance of a contract, right?
Contract to sell for the purchase of real
We
property.
interpret contract based on the language and the plain meaning of the contract itself, right? We usually don't go to extraneous evidence. So where in the contract is there a payment, the payment of $120,000 reflected?
It is not, Your Honor. The reason that they did not include it in there is unclear. It's something that happened a long time ago in 2003, so I can't answer as to why they didn't include it. But what I will point out is there's been certainly substantial proof that that payment was made, and it was made and collected by Mr. Endico on behalf of Baldwin Endico, and that he noted in the payment sheet that the money was to be applied to that contract. Now, why they didn't go on to indicate it in the subsequent contract thereafter, I have no way of knowing. But,
but that's a problem for you, isn't it? I mean, part of the problem is that the contract that was executed and that you're trying to get specifically performed doesn't contain what you said took place prior to the contract, a couple of years before the contract, right? So you have all the causes of action available, including in equity, to try to get that money back. But you know, I mean, you have a problem if you're asking us to interpret a contract that where the evidence that the evidence of this $120,000 is non-existent. So I don't know how we do that as a court.
Judge, and as you point out, it would be inequitable for the defendant to have received this money and my client not having been given any credit at all towards it, when, again, the testimony of Ann Colantuno, who was the assistant to Mr. Endico, was that that money was given to Michael Endico, and that she, in fact, entered it on the payment sheet that's contained on page 123 of the record.
But you just repeated what you had said before. And this is not an equitable action. This is an action in contract. And if there's nothing in the contract that suggests there's anything to be considered outside of it, there's no ambiguity. What's our basis for considering extrinsic or parole evidence? That's the question you need to answer.
I understand that, Judge. The contract itself, however, doesn't contain a merger clause or a typical clause that would say that that there is nothing. Nothing can be included in the contract other than in writing, and there shall be no modification.
You're right. It doesn't contain a merger clause, but it's not ambiguous either. It says that the $5,000 or whatever the amount is that's paid every month, that will be considered. It doesn't say or suggest in any way that there's anything else to be considered.
That's correct, Judge. There was nothing else put in this form contract regarding additional credits. But having said that, again, the money appears to have been paid. There does not appear to be at least.
Well, don't say it again because it doesn't make it any different. Give a reason.
There is no reason, Judge. I cannot interpret what they were thinking.
Part of the problem is, Mr. Centone, that there's no way that we can get to the $120,000 as an extra contractual credit when that will require us to get into parole evidence. And we just don't do that when the contract, as Justice Renwick pointed out, is not ambiguous. I mean, it's pretty clear what the payments were that were made pursuant to the contract. You're trying to specifically perform, get that contract specifically performed. So we're ready to do that, but minus 120.
The second part of that, Judge, is then at the closing that took place at Rocco DiAgostino's office in 2013, in July, when the dispute arose, the offer was made to place the money in escrow in order to adjourn the closing so that the matter could be resolved. The defendants, through their attorney, Mr. Lefkowitz, walked out with his clients, refused.
But wait, but it wasn't, was that simply that you asked, we have the right amount of money and the right checks and everything else, we just need to, let's put this in escrow to see if we can work this issue out? Or were there also issues with regard to the checks? And I think it was made clear prior to the closing that you had to have cashier's checks, you had to have the right amount of money. And instead, I think there were questions as to whether the checks were written out to the right parties and whether it was the right amount of money. So there really wasn't even the amount of money. You didn't have the $1 million minus just the 5,000 ready to put that 120 in escrow with everything else. It wasn't even that. So where would the discussion begin?
Your Honor, in that regard, the contract itself, since we're talking about the terms of the contract, never provided that the checks needed to be certified at closing. Subsequent thereto,
Well, I guess no one would need to do that. That's usually the procedure, isn't it? Isn't that usually what people don't say, come to my closing on my home for the personal check? It's usually a certified bank check.
Your Honor, I agree that typical closings do require certified funds. But if the contract didn't specifically call for certified funds, and the purchaser in this case, Mr. Murray, showed up with some funds that were not, other funds that were,
Two things.
I would suggest that under those circumstances.
Thank you, Mr. Santon. Justice Mendez, you have a question?
Yeah, two things that I have. One thing is that there was a specific direction by the seller's attorney to show up at the closing with certified funds. So that's not something that was sprung on the purchaser at the last moment. And the second thing is that regarding the $120,000, Moray, who was the person who supposedly paid the $120,000, testified under oath in a separate proceeding that he never paid that money. So
Yes,
how does that reconcile?
Judge, there appears to have been some confusion by Mr. Murray in that regard because he subsequently, after having been shown the document itself, testified that this was a credit that he was entitled to. And it goes in line with what Ann Colantuno testified to, that this was a credit that he should have been entitled to for the purchase of that specific property. With regard to your other question, there was a direction that he come with funds in the letter by Mr. Lefkowitz. But I'd like to point out to the court, the first part in the case.
Your time ran out, but I'll give you 30 seconds.
Okay. I said in my brief, the Sosa versus Acevedo on page 24 of my brief, where First Department held that even though funds tendered at closing were not by certified check, that would entitle the purchaser to an adjournment of the closing in order to have time to go and obtain those certified checks.
Is that exactly what the plaintiff was looking for, to adjourn this, so that then, in other words, they would have made an issue out of this whole thing, and that would have extended the date of the contract's expiration. That's what would have happened.
But I maintain that time was not of the essence under these circumstances, Judge. There was no firm time of the essence for
there was a specific date of expiration in the contract.
Okay.
So there was no need for a time of the essence clause.
Thank you, Mr. Santon. Let me hear from the respondent, and then you'll get a chance to continue to address those questions.
Thank you, Your Honor.
Good afternoon, Your Honor. May it please the court. The questioning that was given to the appellant's attorney was right on point. We had a written contract. It was unambiguous, and that's what the court below found. Now, if you look at what happened here with the three attorneys who represented the appellant in this case, the first attorney wrote to the executor of Mr. Endico's estate in 2012, the year before the contract was going to expire, and he claimed that his client was entitled to credits for 2 years prior to the entering into of the contract, $5,000 a month for 2 years, $120,000. Mr. Lefkowitz wrote back and said, no, you're not entitled to those credits. The contract started in 2003, and that's the starting date when the credits began to accrue. So nothing was heard from Mr. Murray or anybody representing him until 2 days before the closing, when his new attorney called Mr. Lefkowitz and said, we want to close this. We want to close it in 2 days. Then he wrote him a letter, and Lefkowitz instructed him as to how to come to the closing. Clearly said that $400,000 was due, and Mr. Murray showed up with $280,000. Then, and Mr. D'Agostino wrote on September 4th, 6 months after the contract expired, we now have the $120,000. And we will put that in escrow pending a determination as to who would be entitled to that.
Mr. Pachesky, what is the evidence? Because I see that plaintiff claims that there were two payments in cash of $60,000 each to Endico, right? And that was done on July 31st of 2001 and August 31st of 2001. Other than the notes, the handwritten notes on a payment sheet, is there other evidence that that money was paid?
That payment sheet is not worth the paper it's written on. There is no evidence that the money was paid. Mr. Murray admitted that he never paid the money in a deposition when his testimony was not being filtered through an attorney preparing an affirmation for him. The next deposition, he admitted that nobody paid that money on behalf of him or his corporation. And then, in opposition to the motion for summary judgment, both Mr. Santone and Mr. Murray said, well, he arranged for that payment to be made. It's directly contradictory to his sworn testimony, which I think is entitled to 100% credence here. He didn't have the money. No payment was made before the contract, and the two parties to the contract had signed a contract 2 weeks before on another piece of property, specifically referring to a pre-contract credit to which USA Recycling was entitled. They knew how to put it down. They didn't put it down. And the two documents that were signed by both these parties are the only documents that have any weight in this case. And it shows that this alleged $120,000 credit is a total hoax.
Okay, thank you, Mr. Pachesky. Mr. Santone, I'll give you a minute in rebuttal.
Yes, Your Honor. Again, with regard to that sheet that we've referenced, it's page 123 of the record, that was a document maintained by the defendants themselves. This was not a plaintiff's created document. It was produced by them.
Yeah, but the handwritten note on a payment sheet that's containing record at 66, whose handwritten notes are those?
Ann Colantuno testified that she had written it down at the request of Mike Endico. That's her sworn testimony at her deposition and in her affidavit. There's no dispute as to her role with regard to—
And Mr. Endico passed away in 2010, right?
That is correct. He did pass away.
Because I can take notes that you gave me $1 million and I can write that down in a payment sheet. That doesn't mean you gave me that, right?
I understood, Your Honor. I'm going by the testimony of Ann Colantuno who testified that this was correct. She was very unambiguous in that regard. At the very least, this creates an issue of fact as to whether or not this payment was made, warranting a denial of the motion for summary judgment in this case. And secondly, the need for, if the question was, if this issue was unclear, certainly an adjournment of the closing could have been had, just to address Judge Mendez's point, that regard to the fact that the contract was ending on a particular date didn't necessarily mean that that's a time of the essence date. A reasonable adjournment could still be had even though the contract called.
But how do you close after the contract's terminated? When you didn't exercise your option, presumably that you're entitled to under the contract, isn't it over at that point?
Well, Judge, they did attempt to exercise it. That's why they scheduled it for, unfortunately, the very last day before. But nonetheless, at that point, they attempted to close, and since they at the very least had attempted to, and everyone appeared for it, I think it's reasonable that an adjournment could have been had to adjourn it thereafter. If they had not attempted to do it all within the 10-year period, I would agree that it certainly would have been.
Whose fault is it that it took that the closing was held so close to the end of the contract?
I have no way of knowing, Your Honor.
Okay.
I assume that.
I mean, you had 10 years, right?
10 years.
10 years. That's correct, Judge.
Okay.
Right.
Thank you both.
Thank you very much. Thank you.
Casita LP.
Good afternoon, Your Honors. May it please the court, Scott Kessler for the defendant's appellants. With me today is Brian Miller, who's been admitted pro hoc vice for this appeal, and we respectfully ask the court to allow him to argue this afternoon.
Go ahead and proceed.
Thank you, Your Honor. Brian Miller. May it please the court. This case raises a lot of the issues we've heard the court discuss earlier today. Under New York law, speculative evidence is simply not legally permissible evidence to support a jury verdict. And that's exactly what's happened here. The jury found the defendants associated with a private equity fund management company liable for breach of fiduciary duty for allegedly not forcing the board of directors of this Parts Depot company to sell that company to Uniselect based solely on the Uniselect letter, which was an initial indication of interest only that came in, and finding one director out of the 6 members of the board of directors liable for the decisions of the entire board at that point in time when the Uniselect letter came in to pursue a more attractive simultaneous overture that came from another private equity fund called Code Hennessy. So the jury verdict was based on speculation as to causation and as to damages. The Uniselect letter, I think, Your Honors, is extremely important to look at. It's in the appendix at 14182. This is the letter that came in. It's about 2.5 pages in October of 2006. And in that letter, on its face, it shows that it was not more likely than not to lead to a consummated transaction. First of all, it has 2 contradictory
So counsel, this is Judge Singh. What steps, once the letter came, what steps did your client take to attempt to consummate the deal?
Yes, thank you, Your Honor. So after the letter came in, the testimony from the board is that the board discussed the letter and also analyzed the simultaneous competing letter from Code Hennessy, made a decision that it on its face was a more attractive and superior offer because there had been a long history of discussions with this Uniselect company that had never led to a deal before. So the board exercises judgment to say that they were bottom feeders and unlikely to close, less likely to close than the other alternative that they did pursue. Nonetheless, however, Your Honor, the testimony was that the process continued. There were 2 investment banks hired. One investment bank, CIBC, was conducted and went out to over 90 different suitors. The testimony was that that company was hired because it had previously worked with Uniselect prior to the October letter to try to get Uniselect to make a deal. CIBC also was a Canadian investment bank. Uniselect was a Canadian company. So the testimony was that the board directed CIBC, the investment bankers, to continue to try to pursue all options, including Uniselect.
Now, of course, the position of the plaintiffs was the opposite, supported by their expert. Doesn't that essentially create, an issue of fact for the jury to decide weighing what your evidence is. Your evidence essentially is that this was speculative, it wasn't going to go anywhere. Comparing it to the evidence that the plaintiff put forward, that in fact that there was a motive here, and the motive was that your client was attempting to continue to recoup certain fees. So doesn't that raise an issue for ultimately just the jury to make that decision?
Well, first of all, with respect to the fees, the evidence at 14277 was that the would be more lucrative to sell the company than to keep the company. But Your Honor, if the expert had relied on facts or data, which is what the Court of Appeals said an expert must rely on to make his determination, we would probably agree with the court. But here it's clear that the only thing the expert relied on was speculation as to causation. We outlined in our brief at pages 39 and 40 all of the many different steps that need to get done before a corporate transaction like this can get closed. It's also important to note that Parts Depot did enter into a contract with another company called Jordan to sell itself, signed an agreement. That's at 13236. I'm looking off to my notes there, is where that letter is in the appendix. And that transaction didn't even close because of the declining financial condition of Parts Depot. So if there were facts and data that Mr. Geiser, the expert, relied on to show that Uniselect would have closed for $200 million, would have closed under alternative 1, not alternative 2, would have completed due diligence, would have satisfied everything. If there were actual facts to back that up, then Your Honor would have a point. But here, the only evidence.
Thank you, Mr. Miller.
Thank you, Your
Honor. Mr. Kessler.
This is Mr. Kessler. I think you're referring to Mr. Katz for the respondents.
Yeah, who's here for respondent Casita LP?
Your Honor, I am. My name is Jerome Katz, and may it please the court, I represent the plaintiff respondent.
So what about that, Mr. Katz? Your adversary essentially argues that your expert impermissibly relied on speculation. What's the evidence, in fact, that the deal could have been consummated?
Your Honor, there is a pile of evidence, and I will give you just a bunch of it right now.
Yeah, just give us the non-speculative one, just to respond to Mr. Miller.
I will give you only non-speculative evidence, Justice Acosta. Uniselect had been banging on Maplewood's door for years. Every year they'd come and say, we want to buy the company, when can we buy it? They were constantly trying to buy the company, not speculative fact. They were a strategic buyer, which meant that they were in the same business as Parts Depot. So the chances of closing a deal and their motivation to close a deal is even greater. They were proposing a price that was exactly the number, the multiple that Mr. Glazer himself had admitted on several occasions was an appropriate number. The investment bankers were urging them to do the deal. These are all non-speculative facts. Plus, they were offering cash.
Couldn't the board make a judgment, a business judgment, say, well, we don't really believe that this company really has the wherewithal to buy it at these numbers, and sale to another company is better, is more in the interest of the company?
The answer is, Justice Singh, a fiduciary, and the defendants here were all fiduciaries, are not allowed to make judgments that are to benefit themselves. That was the issue for the jury.
Well, so the response by your adversary on that issue is that we're going to make a lot more money selling it than the fees we earn from keeping it.
Right, and as we put in our brief, and it's in the appendix as well, the fees would have been double to Mr. Glazer by not selling it. So
whether it was a breach of the fiduciary duty was question number one for the jury, right?
Yes, it was, Judge, and that's a fact issue. What was the motive of Mr. Glazer for not selling the company? Motive is a classic fact issue for the jury. Mr. Glazer, Your Honor, testified for 8 days. 8 days he was on the stand. The jury watched him. They observed him. They observed his demeanor for 8 days. They observed Mr. Geiser, our expert, one of the luminaries in the private equity business, testified at length. Mr. Miller, great lawyer, cross-examined him aggressively, and the jury decided that we were right. We think that that in itself is dispositive in this case.
And the second question was whether that fiduciary duty or the breach of it is what actually caused the financial loss to plaintiff, right?
And Justice Acosta, my previous answer, yes, and my previous answer deals with that, and Mr. Geiser dealt with that. He enumerated all the events involving Uniselect in particular, their repeated interest, the price being right on the number, the fact that they had the cash. He went through all of these elements and presented it to the jury, and the jury found that in light of that, that was sufficient to show causation. And in fact, Your Honor, Justice Reed, the trial judge, actually said, and this is on page 4 of our brief, actually said in his decision denying the post-trial motion, he characterized correctly Mr. Geiser's testimony as having said that there would have been a deal with Uniselect. Do you ever know for sure? No. But in a suit for, and the Kuo case deals with this, in a suit for breach of fiduciary duty, you have to let the fact finder decide on liability and causation, what's likely to have happened, and the jury went our way. We were very gratified that they did, and they similarly went our way on damages, where I know you haven't asked that question yet, but where Justice Reed again said the testimony was not speculative.
Okay. Questions? Thank you, Mr. Katz.
Thank you. Thank you, Your Honors.
So, Your
Mr.
Honors,
Miller?
yes, thank you, Justice Acosta. In order to uphold this jury verdict, there must have been non-speculative evidence that this corporate transaction, a $200 million transaction, would have closed on the terms that Mr. Geiser assumed based on one letter and at a price that he assumed based on nothing but that letter without having reviewed.
Counsel, sorry, this is Judge Renwick. You described the Uniselect as bottom feeders, but if they were bottom feeders and they were bottom feeders that the company decided to court for years prior to that, and this finally, when they get this letter, you just, you sort of say, oh, it was just one letter. It was a formal proposal, wasn't it? I mean, and so
it was not a formal proposal, Your Honor. It laid out.
What was missing from it? What was missing from it to be able to go forward with the deal? What important aspects were missing that would have made this just sort of a backhanded, hey, kind of suggestion?
Among other things, which of the two alternatives would be the offer that one could accept? That's not in there because it laid out two different alternatives for future discussion.
I thought that they had pay. The proposal was to pay cash for 100% of Parts Depot at a purchase price of $252 million. I mean, isn't that a formal, very specific proposal?
Not when you have that price in brackets. That's not a formal proposal. And when a letter has two different alternatives, alternative one is that, alternative two is a different transaction. And recall that the testimony of the CEO of this company.
So what did your client do faced with this proposal? Two options. Did he attempt to engage the would-be purchaser to see which option would work? What did he specifically do?
There had been previous discussions with them.
No, after receiving the proposal.
The testimony was that the investment bankers were directed to go back and discuss things with Uniselect, keep them into discussions while the board pursued the more attractive offer from Code Hennessy. That's really what this comes down to.
But there wasn't a written response to Uniselect, right?
Nor does there need to be. There was not a written response.
I understand that, but if somebody's making that offer and you don't think he's serious, usually you do something about it in response.
You have your investment bankers try to keep them into discussion because you recognize that the letter, which is not an offer under the law, really wasn't that serious. The other options on the table looked much better. So what a rational board does in the business judgment is has its investment banker pursue the more attractive alternatives and keep that potential suitor on the line for potential discussions, which the evidence was that they did. So if this verdict is upheld, essentially managers of private equity funds could be found liable for pursuing a more attractive offer when there's two alternative proposals put to them at the same time. That would be bad policy. And here it's clear that based on what we laid out in our briefs, this was solely based on speculation that the deal would have closed. Even if your honors think that they should have done more to have a discussion with Uniselect, that does not establish causation. That does not establish damages because the expert still has to have a non-speculative basis for establishing that the transaction would have closed at the price that he assumed it would close, and he did not.
Thank you, Mr. Miller. Thank you, Mr. Miller. Thank you, Mr. Katz. New York Times versus City of New York.
Good afternoon, Mackenzie Fillo for the Mayor's Office. This court should reverse because the Supreme Court erred in finding that the charter only protects documents in the board's possession. The most natural and reasonable reading of the charter indicates that documents drafted by the board and sent to others retain their...
Ms. McKenzie, do you agree with me that all documents in the possession of an agency are presumed to be open to the public on the FOIL unless you, the agency, can identify a specific statutory exception? And I would like to point out what the specific exception is for a private warning letter.
The specific exemption is in the charter in 2603K, which says the records, reports, memoranda, and files of the board are confidential and shall not be subject.
You're absolutely right. There is a specific exemption for the charter that says that agency is exempt. But then what about the specific requirements for receiving a complaint, and specifically section, I think it's 2603H34, that talks about making public where you impose or recommend penalties.
Right.
Wouldn't this warning I mean, it says where you do that, where you recommend a penalty, that section, that part of it has to be made public. So if that's true, wouldn't a warning letter be a penalty?
Not at all. A warning letter is not a penalty. They contain no findings of wrongdoing. They say, this is what we think happened. If that's what happened, that would be wrong. And
so
here's why.
A warning letter is a good thing to get.
It's a warning letter. It's an educational tool in the board's that the board has to. The board is obligated to educate public servants about their obligations under the law, and this warning letter is one way that it does so.
So you're saying the warning letter is akin to an advisory opinion then? An advisory opinion is usually before the action takes place. A warning letter is definitely after the action takes place, after the board has had an opportunity to look and consider this and says, this is questionable. But you're saying a warning letter is more akin to an advisory opinion than it is to a penalty.
I would say more akin, but maybe somewhere in the middle. The charter is clear that the board can only publicize findings of wrongdoing after a public servant has had a private hearing where they are represented by counsel. This informal warning letter does not meet those standards. So
Ms. McKenzie, I want to bring you back because I'm not convinced, or I'm not sure where the charter says anything about private warning letters. I thought that, I mean, I looked through that section that you pointed to, and it's not there. It seems that this was a sole creation of the board.
Well,
Which says and you say that you deploy those type of letters when it's insufficient, when the violation is minor, when enforcement would otherwise be based on a new untested interpretation of the law, the instances in which you issue it. But what I want to know is what attaches or what exempts it from the policy choice already made by the legislature on the FOIL, that those documents are presumptively open to the public.
Well, the board's letter qualifies as a record report, memoranda, or file of the board. And those documents are confidential under the plain language of the charter.
Well, the question is not whether they're confidential. The question is whether they're confidential to whom. I know that I mean, you hear the Times arguing that they're confidential to the board because it's a policy choice made to protect the investigative and adjudicatory processes of the board. But it doesn't say that the agency is somehow protected from FOIL.
If the drafters of the charter wanted to just make the board itself exempt from FOIL, it could have done that in a much more straightforward way, like in the case of Newsday, where the definition of agency said except the judiciary. Here, it doesn't say the board is exempt from FOIL or documents in the possession of the board are exempt from FOIL. It says the board's documents are confidential. The focus is on the document, not who possesses it.
So, counsel, I'm sorry, and that's sort of where I want to go with this argument. You raised Newsday, and I do think Newsday and the underlying case, Wayland, do inform us about this case. Once the letter goes to the mayor's office, doesn't the nature of the letter then change? It's an agency letter, and so why wouldn't then the regular rules with respect to FOIL, exemptions that may or may not be applicable then apply? Why wouldn't we look to FOIL at that point as opposed to looking at the charter?
Well, the document continues to be a document of the board, just as this court's opinion continues to be.
In Newsday, the Court of Appeals rejected the argument that the subpoenas continue to be the record of the court. Once the agency gets the subpoenas, they become a record of the agency. So why isn't that reasoning applicable here?
Well, in Newsday, the statutory language they were looking at excluded the judiciary specifically. It didn't say anything about subpoenas or any specific documents. It excluded the entity, the judiciary.
But the Court of Appeals goes on to point that once the ESDC gets the records, they become records of the agency. So don't at that point a separate set of rules, FOIL rules, come into play?
Not at all. Not where there is a statute that designates them as confidential and not subject to scrutiny, which is what we have here. There's just no.
Even if the document is a totally made up document by the board, because there's no such thing as a private warning letter.
Well,
and can you characterize a document in a particular way in order to get around your obligations on the FOIL?
The fact that this provision specifically discusses records, reports, memoranda, and files shows that the charter's drafters presumed that the board would be issuing documents of a variety of kinds of documents. And that combined with the obligation to educate the public servants about the law, that is
you've said this a second time now, educate. And one of the tools you use to educate are these advisory opinions, which are made public. I understand they're redacted, but they're made public. You say that this is not like that. So then this is a warning, a caution, which sounds very much like something that would be a penalty or something. That is made public. If you just let me finish. Those are made public. You have said this is somewhere in between the two of those. Sounds like it's somewhere in between two things that are required to be public.
No, not at all. First of all, when you look at the charter as a whole, it's very clear that the charter intends to protect the privacy of the people whose conduct is being reviewed by the board. Advisory opinions, as Your Honor noticed, they have to be published, but with redactions. The annual report cannot contain details about public servants. The only time a finding of a violation can be made public is after a private hearing where the employee is entitled to counsel. All of this shows an intent to protect the personal privacy of employees, except where a violation has been found after a hearing. Only then is the board allowed to disclose, and is the public entitled to know what happened.
Isn't there another section that deals with the privacy of public officials? I know you don't talk about it a great deal in your brief, but isn't there another section that deals with that?
Meaning under FOIL?
Under FOIL?
Yes, of course. There is the regular personal privacy exemption. And if the drafters of the charter intended that provision to apply here, then they just would not have included this confidentiality provision at all. It would make no sense to include this, to say these documents are confidential, if they expected just the regular, the default privacy exception to apply. Instead, the drafters of the charter.
So I'm a little confused. So does the secrecy extend to the public servant who directly receives the document from the board, or because at another point you also claim that the information is confidential under 2603, no matter which government agency possesses the document. So which is it?
Well, the thing is, sometimes the board sends letters to employees directly, and at other times to supervisors at agencies. So there will be times that it will be in the possession of the employee at home, and there are other times it could be in the possession of a supervisor or at the agency.
And how was this letter sent? Was this letter sent to the mayor at his home address, personal and confidential? I mean, how was this letter sent?
It's not in the record. But the language of the charter makes clear that these documents are intended to be secret, that they are intended to protect the privacy of public servants. And there's just no reason to believe the drafters would have required the board, for example, to redact the advisory letters and publish them, but then anyone can get the unredacted version from another agency that they're sent to.
What's private about an investigation that had been done years before by DOI and that deals with the procurement of fundraising from entities doing business with the city? What's private about that?
Well, the letter contains assertions based on what the board believed happened. It does not. No one had a hearing here. No one was entitled to present their case. There are no findings of wrongdoing in this letter. It is an educational tool.
Well, we don't know that, right? We have to take your word for it.
Well, the board has said publicly that that's how they use these documents. That they're definitely. If it had been a final order after a hearing, the board would be required to publish it.
Yeah.
In fact, unlike many other agencies, which sometimes discipline their employees, and it's all secret. No one ever finds out anything.
How do we get the pedagogical benefits of an advisory warning letter if it remains private? I thought that I heard you say the idea is that all the public servants would heed the advice that is being provided to make sure they stay away from the underlying conduct that's at question, right?
Well, the board engages in a variety of educational activities. It trains people and does all sorts of things. It issues advisory opinions that are published with redactions. But when it's when it sends a letter about something that it thinks happened, but it isn't sure, but it just wants to remind the person that if that's what happened, that was wrong. It does it through this informal mechanism, and the letter is confidential under the law.
Thank you so much.
If I could just speak very briefly about attorney's fees, just 30 seconds.
I'll let you. I've already gave you 13 minutes and 12 seconds. So we're spending a lot of time on this case. I'll let you address that. In fact, let me give you a minute because we want the Times to also respond to it and give
Okay.
you the opportunity to rebut. So go ahead.
Even if this court disagrees with us about the confidentiality provision, the newspaper is not entitled to attorney's fees. This case involves a bona fide question of statutory interpretation and an issue of first impression. There is a reasonable basis for our argument, so the award of attorney's fees is improper under any circumstance. Thank you.
Thank you. Okay, let me hear from the Times.
Good afternoon, and may it please the court. My name is Alamin Sumar, and I'm here on behalf of the respondent, the New York Times Company. In May of 2019, the Times sent the mayor's office a Freedom of Information law request for a single document, a warning letter sent to Mayor de Blasio by the city's Conflicts of Interest Board about allegations substantiated by the Department of Investigation that his fundraising activities as mayor violated conflicts of interest rules. Now, the mayor might have argued that disclosure of the letter would jeopardize his personal privacy. He might have argued perhaps that disclosure would interfere with a law enforcement investigation, but the mayor and the agency did not argue that. Instead,
the only argument is the protection on the 26.3K, right? That they should be kept secret based on that section. So can you address yourself to it directly?
Happy to do that, Your Honor. And I think the questioning that Your Honor is just engaged in, as well as all of the things that we pointed to in our brief, show that 2603K provides ironclad protection for the board's own files. It doesn't reach outside the board and cut off public access to records in the hands of other agencies.
So that's the question I had, counsel, your adversary, is that once the letter leaves the board and it goes into the mayor's office, does the nature of the letter change, and does the analysis then with respect to whether or not it's subject to FOIL change as well?
It does, and Your Honor was exactly right to point to Newsday, because the provision here operates exactly like the definition of agency, or the exclusion of the judiciary from the definition of agency in that case. So if the Times were to go to the board and ask for the letter it sent to Mayor de Blasio, 2603K would apply. But in the hands of the mayor, the statutory exemptions of FOIL.
Well, is it in the hands of the mayor, or that's not in the record? Is the letter now with the agency, or is it clear where the letter is, or where the letter went to?
We have requested it from the mayor's office, and the mayor's office has indicated that there are responsive documents to our request. They were playing a bit of a cat and mouse game earlier. They refused to acknowledge that it did exist, and then in the initial denial, kind of again refused to acknowledge clearly that it did exist. But we know that it exists, and it sits in the mayor's office. And sitting in the mayor's office files, it's subject to the statutory exemptions of FOIL, not 2603K.
Is this any different? Is this any different than Newsday? In that Newsday, the document, the idea was that this subpoena was of the court, but it wasn't something that was kept in the court. It's not something that's held by the court. Once the subpoena is signed, it's the court. It's not in the court's purview anymore. It's up to the person who has the subpoena to use it, destroy it, whatever they end up doing with it. They might not even end up using it. So in that, wasn't it that it was, then it was, so that was a little different is what I'm saying. Whereas here, they are the ones who generate this document. They generate it, they keep it. They're merely sending a copy of it. So they still are the people who have originated the document and hold on to it. And they're merely sending a copy of it to the other person. Doesn't that change this a little bit in the way you look at it?
Respectfully, Your Honor, that was not the Court of Appeals analysis in Newsday. The Court of Appeals analysis was that if you went to the court and sought a copy of the subpoena,
yeah, it said it's a privilege. It said that the exclusion doesn't run with the document. But in that case, it was very different in that the court had a different relationship to the document than the other institution that ended up getting the document. I mean, it just I think it was, I can't recall. what agency it was that was.
It was the ESDC.
That's right, the ESDC. I mean, the ESDC had it. The ESDC was not exempted from FOIL. The ESDC did not create the document. So there was no protection when ESDC had that document. And if it was in the court, maybe that would have been different. If the court had held it, kept it, the document, the subpoena left. It was no longer with the court. It had nothing to do with the court anymore. And so that's why they were saying that, well, that exemption doesn't run with the document. Here, this document, this is in a different position than the ESDC, because here that very document is what's exempted. Those documents that are created and everything else. So that's why I asked the question. It seems like those documents are exempted, but then it seems like there are certain aspects of it that are released from the exemption, because there are certain categories of documents that can be shared, that even are required to be. These, as it was said, these advisory opinions, for example, or these, or things that are penalties, for example. So in any case, I'm just saying it seems like there's a carve out from the exception. What do you have to say to that? Or I guess that's not the way you're looking at this.
Well, I think, reading Newsday, it's not clear to me that the subpoena had left the court. I don't know if there was a copy with the court or not, but in any event, that's not something that the Court of Appeals relies on. What it says is that there is no exclusion of court record in the Freedom of Information Law. There is an exclusion for the judiciary. And so it may be, even if there had been a copy of a subpoena left with the court, that copy would not have been accessible to a full requester. But when that subpoena is in the hands of another agency like ESDC, the regular statutory exemptions apply.
So that's your basis for arguing that 2603K applies only to the board files, not to documents in the hands of the agency of City Hall, correct?
That's exactly right.
You basically, the policy consideration to be made is the policy inherent in FOIL.
That's exactly right, Your Honor, that there is a presumption, a background presumption of access here. As the lower court judge said, there is an overriding consideration that the public is vested with a right to know. And had the drafters of 2603K intended to strip the public of access to any document that's ever passed through the board with all city agencies, no matter what the contents of the document, no matter what the purpose of the document, they would have been clear about that. And that is a flaw with the appellant's argument that they haven't really taken on, is that there is no limiting principle here. This is not a carve out just for warning letters. If the court agrees with their view of 2603K, it would mean that everyone who receives any kind of document from the board, paper or electronic, is bound to keep it confidential. It's a mandatory exemption. It's not a discretionary one. So they would violate
notwithstanding the fact that there's no specific exemption, statutory exception that FOIL talks about.
Well, if the city is right that this document extends, the 2603K extends to every document that the board has created, no matter who has it. And 2603K is mandatory. It says records shall be confidential. Then anyone who discloses anything that they've ever received from the board has violated the law. It's not something you can waive. So if a member of COIB corresponds with the New York City Parks Department to book a venue, and the New York City Parks Department releases that, they have violated 2603K. If there is an email to a reporter at the New York Times about how the board works, and the reporter releases that, they have violated 2603K. That cannot possibly be what the drafters of the charter intended.
So essentially your position is if the charter had created it and kept it, that's one thing. Once the charter shares it, it's subject to FOIL.
That's exactly right. It doesn't mean that it's going to be disclosed. It means that if it's in the hands of the mayor's office and the mayor thinks the disclosure of the letter would violate its personal privacy. So
2603K ties confidentiality to which body possesses the documents.
That's exactly right.
Okay.
Exactly right, Your Honor. And I'm happy to speak to fees unless there's something else very quickly.
Yeah, why don't you address yourself to the fees, because I gave them an extra minute to do that.
And I don't need to go at length. It's just in case the court has any questions. I mean, we're happy to rest on what's in our papers. Just to say that the fees provision was amended in 2017 to give the public's right of access under FOIL more teeth. And they're mandatory when the agency lacks a reasonable basis and the requester substantially prevailed.
Isn't counsel right that this really is something, a first impression that we're all struggling with? And that there may be a reasonable basis to withhold it because of the interplay of FOIL with respect to the city charter and the confidentiality provision?
Respectfully, Your Honor, I don't think so. I think that the city has taken an unreasonable interpretation of 2603K here. And that's clear not just from the language, but the fact that this provision sits in Chapter 68, that it doesn't talk about records in the hands of other agencies, that there is a presumption of openness. And also what I said about the fact that there's no limiting principle here, that the interpretation of 2603K that the mayor's office is offering is veering into absurdity, that it's just simply not reconcilable with common sense. And so it doesn't matter if it's a question of first impression. There are going to be questions of first impression put to the courts all the time. What they're asked is that a reasonable construction of the provision? And this, in our view, is not.
And if you substantially prevail, then you get them.
Exactly.
Okay. Thank you. I'll give the city, I'm sorry, 2 minutes.
Thank you, Your Honor. So the New York Times is dramatically overstating our position here. The board in the charter is defined as 5 board members. So this rule applies to those 5 board members' communications, their reports, memoranda, and whatever the other words are.
But again, counsel, I know that you and I disagree on the impact of Newsday. Once the letter, memoranda, leaves the board, doesn't the Court of Appeals recognize that a new set of rules apply, and that's FOIL because now it is an agency record?
Not at all. This case could not be more different than Newsday. In Newsday, the only thing the agency could point to was the definition of agency that said except the judiciary. There was no language making subpoenas confidential. Here we have language that we can point to saying these documents are confidential and shall not be subject to public scrutiny. And turning back to the exaggeration about what we're saying here is it's just the communications of the board. If some low-level staff member sends some email to the comptroller, that's not covered by this confidentiality provision. There's only a very narrow universe of documents that we are talking about here, and it's the reports and memoranda of the board. And the board, as defined in the charter, is 5 members.
There are documents that are specifically exempted, right? So say, for example, a report by the commissioner of DOI to the board, that's specifically exempted, isn't it?
It is, and
it seems to me that when the charter wants to exempt something, they can do that, and they've done it. The question is, where is the protection for a document called a private warning letter, which is really, I mean, the Times argues that it was really manufactured by the board, 5 appointees of the mayor himself, who's a recipient of the letter. That's what I hear the arguments being.
The letter plainly qualifies as a report or memoranda of the board. And again, the charter makes those documents confidential. It doesn't talk about the board is exempt from FOIL. It says these documents are not to be subject to public scrutiny. I would also like to respond to my colleague's comment about if someone disclosed something, then they would be breaking the law. A person who has a personal privacy right can waive that right. It happens all the time with medical records or attorney-client privilege. So if someone who is the subject of a board letter wants to release it, they're free to do so. The point is that the court cannot compel them to do so where they choose not to. That's what this provision means when it says that these documents are confidential.
But you haven't asserted the reputations of livelihood privacy exemption in this case, have you?
We have not, because the language that we're relying on is much broader than that. It says all these documents that the board issues are confidential. It's much broader than the personal privacy exemption.
Okay. Thank you so much.
Thank
you both.
Thank you.
Great arguments. Luciano Mahoney versus Rossman.
Good afternoon, Your Honors. May it please the court, on behalf of appellant, this is Todd Restivo, and I'm joining you with audio capabilities only. May I proceed?
You may proceed, Mr. Restivo.
So, Your Honors, the appellant is entitled to summary judgment based on the undisputed facts in this matter. The undisputed facts, just to summarize, defendant had a stop sign, plaintiff did not. Defendant was coming from behind a train trestle. Plaintiff and defendant's wife saw each other a second or so before the collision as defendant was accelerating into the intersection. Respondent's front end struck the appellant's driver's side. It's clear from the testimony that the appellant was not speeding. It's also clear from the undisputed testimony and facts in this case that the respondent first saw the appellant when the appellant was inside the intersection, and as he states, right on top of him.
And Counselor, I'm sorry, this is Judge Singh, and I apologize interrupting, but what duty does your client owe as she's coming into the intersection?
Duty of reasonable care, Your Honor.
So duty to see what's there, for example, right? So if there's a car in the intersection, does she have a duty with respect to it? Obviously, you got to brake. You can't just run into the vehicle, no?
Well, sure. Her duty would be to again act reasonably. She can't act unreasonably under the circumstances. And the circumstances in this case, I mean, certainly no one is just entitled to recklessly or with wanton disregard drive through an intersection. But if you're coming through an intersection that's essentially blind, and in this case, Your Honor, you have the respondent running into the side of my client's car. And my client had a second or less or so to react.
Mr. Restivo, but Mr. Rossman testified that when he arrived at the intersection, he stopped, he looked right and looked left, and drove straight through across beach because he did not see any vehicles. So it's not as if he blew the stop sign, right? He looked, he stopped, he looked right, he looked left, didn't see anything, moved on. And then that's when he all of a sudden saw your client's car coming in. So doesn't that create an issue of fact?
No, I don't believe it does, Your Honor. I mean, the duty that the respondent had in this case was not only to stop at the stop sign, but it was also to yield the right of way to any vehicle that was either in the intersection or approaching so closely.
But he can't yield the right of way to something that he doesn't see, to something that's not there. And isn't the question that needs to be determined by a jury whether, in fact, he should have seen your client's car approaching? When he looked left, when he looked right, he should have seen something that was there. He said he didn't. So, but
oh, I'm sorry, Your Honor. I didn't mean to talk over you. I thought you were
No, go ahead. Go ahead.
Your Honor, I mean, somebody could testify that they looked right and they looked left 5 separate times in each direction before they pull into the intersection. I don't believe that absolves their duty to make sure that it's safe to proceed. You know, he claims to have looked left or right, yet he didn't look obviously close enough to see what his wife was able to see, that there was an oncoming car. So he can claim he looked to left and right, but based on the undisputed facts in this case, my client was so close to the intersection that he ran into the side of her car as he tried to drive through it. So I don't think there's a material or genuine issue of fact that no matter that a jury would need to decide in this case to determine that he's negligent in approximate cause of the accident.
Okay. Thank you, Mr. Restivo. Let me hear from the respondent in this case.
Good afternoon. Matthews Rib on behalf of the respondent, Larry Rossman, and the remaining respondents. May I proceed?
You may.
May it please the court. It's well-established law in New York that just because a defendant has a stop sign and another driver approaches an intersection and doesn't have a traffic device is not a basis for summary judgment. In the Supreme Court's order, the judge found that there was an issue of fact as to the occurrence of the incident, and it's our position that in this case, the plaintiff has not established as a matter of law that that Mr. Rossman failed to yield to oncoming traffic.
Hey, counsel, is your adversary right that your client's car, in effect, ran into the plaintiff's vehicle, just in terms of where the impact was?
I do not believe so. I believe the front end of both cars, as it were, struck each other in the intersection.
So it wasn't on the plaintiff's side?
It was on the plaintiff's driver's side by the front wheel.
So if it's on the side, wouldn't that suggest that she was already in the intersection?
Yes. Even if that is the case, plaintiff has not established that she used reasonable care as she approached the intersection. Mr. Rossman testified that he stop sign, looked both ways, and proceeded into the intersection. Plaintiff testified she did not see a vehicle at the stop sign. She saw defendant's car a split second before the impact. So both drivers testified they saw the other vehicle a split second before the impact. This is a clear issue of fact for a jury to determine whether VTL section 1142A was violated.
I guess what I'm asking you is, does the physical evidence support your client's version of the events?
Yes, it does. He testified that he stopped at the stop sign, looked left and right, and proceeded into the intersection. But
runs into the side of the front side of her car.
Even if he struck the front side of her car, plaintiff has not carried her burden in establishing that Mr. Rossman failed to yield the right of way.
Thank you, Mr. Tripp.
Thank you very much.
I'll give you 1 minute, Mr. Restivo.
Thank you, Your Honor. So, Your Honor, I mean, really, it's important to appreciate that there's different burdens or different duties, rather, that apply to both parties here. And the clear language of VTL 1142 states that the defendant cannot proceed if it's unsafe to do so. And here he drove straight into the intersection and ran into the side, and that's undisputed in the record, into the driver's side of my client's car.
But that begs the question, right? I mean, let's assume for the moment that the respondent looked left, looked right, saw nothing, no vehicle coming in, entered the intersection, and then your client was driving at 75 miles an hour, and that's why he was not seen in time to prevent that car from hitting him. Would that?
Your Honor,
go ahead.
Your Honor, there's no evidence here to support any indication that my client was speeding. You know, there's cases that are cited in the briefs by both parties.
Isn't it implicit? Isn't it implicit that if I'm at an intersection and I look left and I look right and I look well and I don't see any vehicle coming, and then once I'm in the intersection, I see this vehicle right on top of me, that vehicle got to me in the time that I was able to enter the intersection and look for any other car coming in, right?
Your Honor, actually, I believe that's been addressed in both. It was addressed recently in Lugo versus Daytona Auto Sales. Mm-hmm. And the indication is an argument such as that would be speculative. Unless there's actual proof that you saw or you can determine the speed of a vehicle, just a simple argument that, well, it must have been speeding because I looked so careful and I didn't see it. That's quite different than an argument such as in the Navarez case, which I believe was written by Judge Renwick and concurred by Judge Acosta. And in that case, you have different.
Who are those judges?
Your Honor, in that case, you found that there was a clear issue of fact, right? There was an issue of fact about speed. One party says a vehicle was going 10 or 15 miles an hour. The other party says that the vehicle was going 40 miles an hour. And in that case, ironically, the defendant broadsided the plaintiff and not the other. The defendant was a moving, I believe. And in that case, the moving broadsided the non-moving, which is the opposite of what happened here. So under certain facts and circumstances, but just claiming, well, I looked so closely and there was no vehicle, it must have been speeding. That's been disregarded by the court by legions.
Thank you, Mr. Shrip. You
Yes.
don't have rebuttal. You don't have a cross appeal, so you cannot address the court. So thank you, both Mr. Restivo and Mr. Shrip.
Thank you.
Thank you, Your Honor.
Valley National versus Page One.
Good afternoon, Your Honor. John Gireller, Claystad and Winters, on behalf of the defendant appellant, Page One LLC. May I proceed?
You may proceed, Mr. Jordan.
May it so please the court. Your Honors, this is an appeal from a denial of a summary judgment motion by the trial court. It is submitted that this is a very straightforward contract interpretation matter. The terms of the contract are clear and unambiguous. As such, interpretation is a matter of law for the court. The operative.
Counsel, this is Judge Singh. So a termination agreement gives plaintiff an option to enforce loans, quote unquote, designated as buyback loans. But in Schedule A, you don't designate what loans are to be bought back. How are we to interpret that?
Your Honor, good question, and that's the issue at hand, right? So the document itself says that only those designated, and that's the use of the term.
What does designate mean? What does designate mean?
Well, designate to me, and I think the plain language of it is to identify, to specify, to indicate, by an asterisk, by a highlight, by a footnote, something that is a buyback loan. So timing is very important here with respect to this issue. So there were negotiations that had been ongoing through December, January, February. In the meantime, or at the same time, the transaction documents were being prepared. The issue of whether or not the buyback obligation from the underlying participation agreements, and there was 3 out of 17 as part of this loan portfolio that had these buyback provisions. The negotiations regarding whether the buyback provision would be terminated was still ongoing. The last that the defendants had heard from the bank was that the bank had done their analysis throughout January and was making a report to the higher ups to get approval to terminate those buyback provisions. However, at that time in February, the buyback provisions had not yet been agreed upon as being terminated in full. The language that's in the agreement is conditional, and you see this in a lot of contracts. That the purchase agreement incorporates assets that are listed on Schedule A. Now, Schedule A may change from the time that it's first produced until the time of closing. So what is the operative date here? The operative date is in May of 2017 when this matter closed. From the end of January to May, there were no discussions with the bank regarding the termination of the participation agreement. The last that the defendants had heard was that it was being recommended to the bank higher ups that the buyback provision be terminated.
So, Counselor, it strikes me that you're not really arguing a straightforward breach of contract. You're saying we got to look at the circumstances, what was going on, to put it in context to see what this means, right?
Well, I think it's 2 things, Your Honor. I think number 1, the language is very straightforward. Nothing in Schedule A is designated as a buyback loan. as
So
of closing.
could it be a mistake? Could Schedule A be a mistake where it's placed?
There's been no argument. There's nothing in the record that it was a mistake. All we know was that the bank officer, the bank's in-house counsel, prior to closing, reviewed several iterations of Schedule A and never raised an issue with respect to anything being designated. We also know, and this goes to your question about the context, right? The context is important, and I think it helps, although it's not necessary for the interpretation of the contract, it's important and it helps show what the intent of the parties was. And the parties' intent was that these termination agreements would be eliminated. And that's the last that we had heard. But again, it doesn't matter, because what the plaintiff gets caught on is the term designate. And no matter how you look up the designation, the definition of designate, there's nothing in Schedule A. You can look at Schedule A upside down, left and right. There's nothing in Schedule A that says that there is a quote unquote buyback loan as part of that. And the reason why that was conditional is because there were 3 out of 17 had buyback provisions. My clients said, we will only do this deal, which is basically, we'll give you all these loans for $1 as long as the buyback gets eliminated. There wasn't a decision on that yet. So that's why that language is conditional. So you have to go to closing. And what happens at closing? Nothing was designated as a buyback loan. I mean, very easy to know that the plaintiff's argument was, well, that makes that statement unnecessary. Well, it doesn't, because in February, there was still a negotiation going on, and it's a conditional language you see in a lot of contracts. The second argument is, well, we assume that if there was a buyback provision in the underlying participation agreement, then that means that if it's listed on the portfolio of loans, then that should be included as a quote unquote buyback loan. But you know what? There's no support for that at all. You can go through the entire documents, you can go through the entire record. There's nothing that allows for that assumption or that presumption or that implication.
Thank you, Mr. Jarrell.
Thank you.
Let me hear from Respondent Valley National.
Thank you, Your Honor, and may it please the court. Bruce Goodman on behalf of Plaintiff Respondent Valley National Bank. I'd like to correct a misstatement of fact that my colleague made concerning the record. He said that there were negotiations, and I don't know that it's necessarily relevant because I think the contracts are clear and unambiguous and mandate an award of summary judgment in favor of the bank. But what my colleague just said is that there were negotiations going on between the bank and Page One in December, January, and February concerning this buyback provision and whether it would remain, Page One would remain liable for the buyback provision. And that thereafter, they never heard from us again. So they just assumed that we agreed that they weren't going to have to buy it back. And that's simply wrong. It's in the record that what we said to them was, regarding the must-pass loan, which is the loan at issue in this case, the bank requested certain financials from Page One concerning that loan. And they said, we'll consider your request that we forego requiring you to buy back this loan eventually, but we need these financials first in order to make that decision. And we never got the financials. It's undisputed. It's not disputed in the record, and there's nothing in the record to show that we ever got the financials. Okay, when we didn't get the financials, and the bank received the draft of the participation termination agreement along with the sale and assignment agreement from Page One's in-house attorney, and again, this is in the record, we came to the conclusion that great, they're not going to contest the fact that they're going to be liable to purchase, to buy back.
You know what I don't understand, Mr. Goodman? I don't understand, and you know, there may be a legal answer to it, but just from a business perspective, that a party would agree to convey its remaining interest, which has value, for nominal consideration, without getting a benefit in return for that. Maybe, I guess you could argue they just made a bad deal, right?
Right. Well, they made a bad deal, and you know that happens sometimes. Either they made a mistake in calculating whatever.
Well, could it be that both parties maybe made a mistake here?
No, Valley National was very clear, and it's in the record. Once we received the draft of the participation agreement from their in-house counsel in March of 2017, and it didn't change from March to the closing in May of 2017. Maria Gugliuzza, who was the bank officer charged with handling this deal, wrote an internal email and said, "Oh, they're not gonna require us to give up our buyback provisions." At that point, we had never gotten the financials that we requested, and Mr. Gereller's argument relies on the fact, well, at closing, there's going to have to be, we were going to have to sit down and put an asterisk next to the must-pass loan, or it was going to have to be highlighted. But there's nothing in the deal documents. There's nothing in the record which suggests that that was going to be the case. There's no
termination agreement says designate.
Right,
and that wasn't accomplished. Or that wasn't done.
No, it was done. The designated buyback loans are, and there's no dispute which ones they were. They were Sparrow, and they were
designated. So the 2 or 3 loans that had these provisions, they were designated in Schedule A.
And he misstated. There's actually 2 loans at issue in this case.
Right, that's what I recall too. Yeah.
Yeah, there's 2. There's not 3. There's 2 loans, Must-Pass and Sparrow. The designated buyback loans are the loans that have the buyback provisions in it. That was what the parties' discussions were throughout. And when we got there,
wait, doesn't designate require you to do something? Designate. It would seem to me that if you use that as a term of art, that means you have to highlight it, do something.
Not in the way the agreement is drafted. If the agreement had been drafted to say the designated buyback loans, perhaps, but it's not drafted that way. It's drafted as designated as buyback loans, and the buyback loans are Must-Pass and Sparrow. Those are the buyback loans. So, what Mr. Gereller is essentially arguing is that provision is meaningless. It shouldn't even count, because if we were just going to give up our right to demand that they buy back the Must-Pass loan, we wouldn't have even needed that provision in the participation termination letter. We could have just had the sale and assignment agreement and said, you're selling us this portfolio of loans, and we're terminating all participation agreements regarding each of these loans. Full stop. The reason we had the separate participation termination agreement and this particular provision in it was we were negotiating whether or not these loans were going to be subject to buyback, and they are. That's why we drafted the letter. That's why we agreed to it this way.
Okay. Thank you, Mr. Goodman.
Thank you, Your Honor.
Mr. Gerella.
Thank you, Your Honor. And I just very quickly, I just wanted to hit three of the points. The first provision as to whether I misspoke. Yeah, the court can refer to page 82 of the docket, which shows the testimony of Ms. Gugliuzza, where she indicated that she was actually making a representation and seeking approval from the bank that all the buyback provisions be terminated. So she had obviously received all the financials and information she needed at that point. The second point that the counsel made was, and I think Justice Singh picked up on this, that maybe it was a bad deal. Well, you know, it was probably a bad deal for the bank, and that's why they're coming back now and trying to undo the deal. The third point is the term designate. Designate is a defined term. There's a reason why it was used. If they want all of the all of the buyback provisions were going to remain in place, they could have very easily said that as well. The bank didn't do that. The schedule didn't identify or designate or any of the definitions of designate on Schedule A. No one would have any idea because there's nothing designated. So therefore, all of the buybacks were terminated as part of the deal. Thank you.
Okay. Thank you. Thank you both. Portillo versus DRM-BRE, 85 feet.
Good afternoon, Your Honors. It's William Gaggus, Costa, Brady, and Nagler on behalf of the defendants, respondents. May I proceed?
You may proceed, Mr. Giddens.
Okay. May it please the court, this case is a labor law action wherein we request that this court reverse the lower court's finding granting summary judgment in favor of the plaintiff. We believe there are clear factual issues as to proximate cause regarding the ready availability of ladders at the job site and the plaintiff's response thereto. And if I just point the court to page 9 of the record, which is the lower court's decision, the first full paragraph on that page, the last sentence, the court engages in fact-finding and credibility weighing, which obviously it cannot
do. Counsel, this is Judge Singh. Yes. Why don't you tell me, let's put aside what Judge Kalish said. What should have plaintiff done in this situation for you to raise an issue of fact on sole proximate cause?
Well, what he
plaintiff
should
says he looked for a ladder for 5 minutes. He had observed his supervisor perform the same task, both on a ladder and a turned up bucket. Couldn't find the ladder in the 5 minutes, and then he emulated his supervisor and performed the task the way he was shown. And I also don't think in this record there's any indication that the worker or the plaintiff was told not to use a bucket to perform overhead tasks.
Well, this speaks to the Robinson case, which is a Court of Appeals case 6NY 3rd 550, which is similar in that regard, in that the plaintiff had a 6-foot ladder available to him and chose to not use an 8-foot ladder, which would have been suitable for the work to perform. Here, the plaintiff chose the bucket as opposed to a ladder. And,
but where was he getting the ladder from in this case?
Well, the plaintiff himself testified that there were 2 to 3 ladders always available at the site. There was one in the room where he was working, which his coworker was using. He specifically stated that the other 1 to 2 ladders would be in the other 4 to 5 apartments that his employer was renovating, one of which could have been either the 35th or 36th floor, right above where he was working. He stated he did not even spend 5 minutes looking beyond his immediate location and did not use his cell phone to call his boss to ask for another ladder or another device.
Counsel, is it the responsibility of the worker to have to go in search of the ladder to different floors in an apartment building to find out if there's an operable ladder that he can use? When I think that the person who sent him, he was instructed along with his coworker to do work in that apartment, work that required some device to get up. And there were 2 workers and 1 ladder. How were they supposed to accomplish the work if they were only given 1 ladder? And they both needed the ladder. I'm just, how far and wide, and is it the responsibility of the worker to search for the device?
Well, there would be some responsibility, and what the real crux of the issue is whether or not, what rises to the level of summary judgment. And what the courts have said is really, in terms of a plaintiff obtaining summary judgment, it has to be undisputed in the record that those devices were not available whatsoever. And that is the Rice case.
Okay, but let me stop.
What about the fact that he used a bucket only after seeing his supervisor do it?
I'm sorry, Your Honor, I didn't hear your question.
I said, what about the fact that he used the bucket only after seeing his supervisor, or his supervisor, Ray, I think it is, do that same thing to accomplish the particular task?
But again, I think that speaks to a factual issue. That's certainly something that would weigh in the plaintiff's favor. However, similar to the Robinson case, where the court said the Court of Appeals found in actually summary judgment in favor of the defendant owner, where the plaintiff did not look beyond his immediate work location, wait for one of the 8-foot ladders to become available, or reiterate his request.
So how long do you think he should have waited, Mr. Gayas? I mean, what does he say? He looked for 5 minutes and then decided to use the bucket, as he had seen his supervisors do, in order to perform what he characterized as a 15-minute task. So he should have looked for an hour, half an hour.
And just to piggyback on that, the other worker at the site told him that he was going to be using the ladder for a while because he had a lot of work to do and he wanted to finish his work. So how long was he supposed to wait also?
Again, I think those go specifically to the plaintiff's credibility of this unwitnessed accident, and it's his testimony that this was a 15-minute task. And I think the lower court improperly does make those findings in favor of the plaintiff and does not provide any basis of the facts.
Are you contradicting it by evidence, saying in fact the task would take 2 hours or 3 hours? Other than his statement, is there anything else in the record to suggest that in fact it was more than a 15-minute task or less than a 15-minute task?
Not specifically to the length of the task, because again, this is goes to part of the argument in the brief that this was an unwitnessed accident. which was not corroborated in any written document until 3 weeks later when he presented it when the hospital.
And you have some
However,
arguments to make with respect to the injuries, but the fact that it's an unwitnessed accident is not a basis to deny summary judgment, no?
I believe actually there are cases that say when the defense has raised a bona fide issue with regard to the circumstances of the accident, summary judgment is not appropriate in that circumstance.
But we also have plenty of First Department precedent that doesn't require that. In fact, many of these accidents take place with workers that are working on their own. In this case, in particular, other workers that were nearby heard the fall, and they testified to it. Did they not?
There was no testimony, Your Honor. That was the plaintiff's testimony that his workers had heard his fall and that he came to him. I don't know if it was one worker or just Derek that was in the unit. But the Antunes First Department case considered a similar circumstance where a worker had been working on a ladder which slipped on some silicate on the floor. And in fact, the witness coworker had submitted an affidavit in that regard. And the court found that in and of itself, because it's based on information exclusively within the knowledge of the moving party, or clearly not within the knowledge of the opponent, summary judgment was not appropriate.
Thank you, Mr. Gagas. Let me hear from the other side. You got a minute coming back.
Thank you, Your
Honor. Mr. Shields, we can't hear you. You got to unmute.
Better?
That's better.
Okay. Good afternoon, Your Honors. May it please the court. I'll just jump straight into some of the things that counsel hit on. The Robinson case he cited, and along with pretty much every other case that they cite in their papers, are distinguishable because in those cases, there was actual evidence that the plaintiff knew exactly where a ladder was.
But surely is that the law? The law is that the plaintiff has to know exactly where the ladder is. Aren't the statements a little more general that they need to be available safety devices on the job site? And it's your adversary's position. The job site is the 3 or 4 apartments that they were renovating.
Well, that's not the law, but in that Robinson case, it was the facts were very specific that he knew there was an available ladder in the basement that wasn't being used. In this case, the defendants are apparently asking the plaintiff to go on a search of the building for
not the building, just the apartments that are being renovated. And I think it's your client's testimony that he was moving from apartment to apartment. So is that unreasonable?
Yes. And especially in light of the fact that there were at most 3 ladders for 6 workers, and he testified that the ladders were mostly always used.
May I just ask how many floors were these apartments on? Counsel said that there were 3 or 4 floors, something like this. Was it?
It went from the 5th to the 34th. I believe it ranged from the 5th to the 34th, Your Honor.
And where were the particular apartments? Where were the particular apartments?
5th. One was on the 5th, one was on the 34th, and it escapes me what the other 2 were. I can check and see here. I've got the wrong thing.
I'll give you another 10 seconds to look because I think I've given you plenty of time.
Well, I'd just like to point out before I lose my time that, I had the pleasure of arguing an almost identical case before Your Honors 6 weeks ago, and the name of the case is Garces versus Windsor Plaza. And in that case, both Justice Mendez and Justice Renwick signed on to that decision. And it was a nearly identical situation where a plaintiff had fallen and there was not a ladder available. And the quote from your court was, even if an adequate ladder was readily available on the construction site, the defendants failed to show that the plaintiff knew that he was expected to use it or that he chose to do so for no good reason, citing the Bianca case. And that goes along with the 2 cases that we rely on in our brief, which is the the Ariana versus Biltmore and the Cherry case, where this court held that, quote, the general availability at a work site does not relieve a defendant of liability, and that there's no obligation to search the building for a ladder without knowledge of the exact location and its availability.
Thank you. Thank you, Mr. Schiff.
Thank you, Ron.
Okay, Mr. Gagas, I'll give you a minute.
Okay, just briefly on that last point, in the Cherry case, the court actually held there were factual issues precluding summary judgment in that case. And plaintiff cites dicta, and that's all laid out in our brief. What is important here is to recognize the procedural posture of these cases, because in the Robinson case and the Montgomery cases, the Court of Appeals cases, they're actually finding summary judgment for the defendant and determining exactly what ready availability and logical and normal response is. So we're not even trying to get to that level. We're just saying that those issues are still something we're entitled to prove at trial. That's where the lower court erred in making that determination on a summary judgment motion. And in fact, the plaintiff himself admits his normal and logical response was to look for a ladder at page 156 of the.
And I'm sorry, but he did look for a ladder. He spent some time looking for the ladder, couldn't find the ladder, and then used the upside down bucket as his supervisor had done. Right? So is he under that fact pattern? Is he the sole proximate cause, or really what we're talking about, comparative negligence, which of course is not available under this particular section?
I believe the defendants are entitled to make that showing at trial, whether or not that conduct constitutes sole proximate cause. And I think it does align with the cases that when you do know there are ladders available, he could have called his supervisor, could have done other things. And just briefly, what is also important is that the only circumstances where summary judgment for a plaintiff is appropriate involves the Miro case and the Masulo case, where it was absolutely undisputed there was no ladder available, which obviously is not the case here. And this just does not rise to the level of granting summary judgment for a plaintiff.
Thank you, Mr. Gagers.
Thank you very much.
Thank you.
Gagliano versus New York City Fire Department.
May I proceed, Your Honor?
You may.
Thank you. May it please the court, my name is Kenneth Gordon. I'm the attorney here for the petitioner, John Gagliano. The issue here is a very narrow one. The question is whether the city and the fire department can ignore their standards and disqualify a candidate for the position of firefighter based solely on hearing loss he has in one of his ears. Now, we're very fortunate in this case because here the city has adopted the standards that are published by the National Fire Protection Association. And the standards there are very clear. They distinguish between what's called category A hearing loss and category B hearing loss. And there's no doubt that Mr. Gagliano has perfectly good hearing in one ear, his better ear, his right ear. And it's quite clear he has some hearing loss in the other ear.
But counsel, under that category B, for example, it says that it's possible for someone with the hearing to work, but it says it's not automatic. This qualification is not automatic, but it's still, is determined by whatever the results of the testing are. And didn't the expert for the city demonstrate that Mr. Gagliano had loss that could deteriorate further, or even with the testing that he wouldn't be able to hear maybe the sound of a voice, if he was in a fire situation? Weren't those the reasons that distinguished one expert from another here?
No, Your Honor, Dr. Beecher, the city's expert, did nothing to evaluate whether Mr. Gagliano could hear using both ears, other than say, let's look at the audiological reports and see what's wrong with his inferior ear. There's no question that Mr. Gagliano has loss in the one ear, but under category B, which the NFPA was very careful to distinguish from category A, it's not sufficient just to say you've got loss in your better ear, in your inferior ear, and that's the ball game. There's an issue that has to be addressed, and we're not talking here about a battle between the experts, where our expert tested the hearing of Mr. Gagliano in both ears and reached one conclusion, and the city's expert did something else. The city's expert never tested Mr. Gagliano and found out to determine whether he could hear adequately using both ears. Now, there's a lot of anecdotal evidence to suggest that he definitely can do so.
Yeah, no, she found simply that, she found that he was the category B, and she also found that the unequal hearing loss would be a basis to disqualify him because of the background noise versus, in high noise environments, I think.
But she did that solely by looking at the results in the better ear and did nothing to test it. Now, there are various ways to test it. Our expert, Dr. McVitie, did conduct various tests. We're not saying that that's the only way to test it. But Dr. Beecher did no such testing of any kind. She did nothing to determine.
What about the issue of his progressive hearing loss?
Yes.
That could further impair his ability.
Well, first, and I have to apologize for one thing here, Your Honor. There's a typographical error in the brief on page 19. I refer to something on page 7 and 8 that really is on page 13 and 14. But we have the audiological. If you look at page 13 and page 14 of our original brief, you can see that, in fact, Mr. Gagliano has not suffered progressive loss of hearing. If you look at his right ear, his hearing as of 2017 was every bit as good as it was in 2011.
But Counselor, this is just saying.
Wasn't he diagnosed as having profound sensorineural hearing loss in the left ear?
He has significant, no question, Your Honor. Mr. Gagliano has hearing loss in the left ear such that if that were his better ear, he would be category A. The issue here is when you have someone who has excellent hearing in one ear and significant hearing loss in the other ear, what does the NFPA require?
I understood the record to suggest that the sensorineural loss of hearing in the left ear prevents him from locating the source of noise under certain circumstances, right?
But nobody ever, Your Honor, nobody ever performed the test other than our expert to determine whether that's the case.
How would you figure that out? I mean, how would you do a test like that? I mean, that's essentially an opinion that because of the condition of the ear, he won't be able to maybe find a victim of a fire.
Well, there are a couple of ways. I can suggest some ways to do it, but I would, before I answer your question directly, Your Honor, the NFPA makes it very clear they're not requiring any particular test. So they don't say this is how you have to do it. We know anecdotally that Mr. Gagliano has been HASDAC certified since 2013, which requires him to maneuver within a smoke-filled and a dark environment based solely on hearing and on touch, and he's able to do it. That's one way to test it. Dr. McVitie did a different kind of test that doesn't directly deal with direction, but does deal with the ability to parcel out background noise.
Thank you, Mr. Gordon.
Can I just ask one additional question? So does this fact that, looking at the background noise, one party says, well, it's okay that he can hear this background noise. Another person says, well, he's in this category B and background noise may be an issue. Does that render this arbitrary and capricious?
It's arbitrary and capricious if you don't do something to test that. Dr. McVitie performed a test to see how he's affected by background noise, the Quicksand test.
So the exercise of discretion has to be supported by something.
Yes, someone has to make an effort.
Okay.
Let me make it clear. Mr. Gagliano does not want to put himself or anybody else at danger, but he's currently serving as a lieutenant. He operates at fire scenes, operates in the building, 1 or 2 floors below the fire, and has to be able to locate and deal with that. So obviously the fire department knows he can do that. All we're asking is that he be fairly tested under NFPA and somebody determine, not because they're guessing based on one ear, but how well can he hear with both ears. And if there's a fair test done, which Dr. Beecher did not do, if there's a fair test done, and we really had the battle of the experts, Dr. McVitie said one thing and Dr. McVitie said something else, then the city's argument would hold some water. That didn't happen.
Thank you, Mr. Gordon. Ms. Paulson? You need to unmute.
Thank you, Your Honors. May it please the court. And I apologize because I hear the snowplow and I'm afraid that my dog is going to bark. I'm hoping not.
Don't worry, the vicissitudes of virtual oral argument.
Exactly. As Judge Redwick recognized, what the Category B requires is a risk assessment. And that's what Dr. Beecher, the Deputy Medical Chief Director of the FDNY, had to do. There is no dispute here about the medical evidence. Dr. Beecher recognized all of Dr. McVitie's test results and analysis of the extent of both Mr. Gagliano's hearing loss and Mr. Gagliano's hearing abilities. She not only recognized and did not dispute any of the medical evidence, she recognized his work experience, his ability to perform as a volunteer firefighter in Westchester, his ability to perform as an EMT and paramedic in New York City. But what the NFPA standards require is not additional testing if the test results are undisputed. What it requires is a risk assessment and a determination of whether or not they believe that the officer can safely perform the essential functions of a firefighter. And in Dr. Beecher's opinion, because of the undisputed results, and she recognized his quick SIN test, his ability to hear sounds embedded in background noise, but she also recognized some increased hearing loss, which his own expert, Dr. McVitie, also recognized on page 104 of the record. She said it was not significant, but she did not dispute that there had been some deterioration. She also did not dispute that he's at risk of continued deterioration due to occupational hazards and otherwise. The only place where they dispute is his private audiologist did not believe that his hearing condition would impair his ability to safely perform the essential functions of the job, and the Deputy Chief Medical Officer of the FDNY required for evaluating candidates did believe that those same conditions, not disputing his abilities in any way or his disabilities in any way, but she believed that they could impair his ability to do so. The Civil Service Commission it was not arbitrary and capricious for the Civil Service Commission to decide to rely upon the decision of the Deputy Chief Medical Examiner of the FDNY, who was more intimately familiar with the job responsibilities and decided several of the things that Judge Renwick noticed, his ability to perceive critical low volume sounds, to engage in accurate receptive communication, to accurately localize sounds in a high noise environment could impair his ability to safely perform it. She recognized that he had been safely performing his job duties to date. She did not disregard that fact at all, but she was charged with determining whether or not there might be a risk to himself, to his colleagues, or to the public if he was appointed as an FDNY firefighter. There was nothing arbitrary and capricious in the Civil Services Commission to rely upon that decision, and it should be affirmed.
Thank you, Ms. Bolton.
Thank you, Your Honors.
Mr. Gordon, you get 1 minute.
Thank you, Your Honor. The issue here is simply one of who has tested Mr. Gagliano and tried to determine, not based on guessing, not based on what you think might happen.
But what do you say to Ms. Paulson's position that there's no requirement of actual testing? She says that really it's a risk assessment that is made, and Dr. Beecher, in the context of undisputed medical evidence, made a basically did not oppose it.
But Your Honor, had that been the standard in the NFPA, they would have made this a Category A hearing loss. The initial risk assessment, we're dealing with a standard. And the NFPA didn't say, well, if you've got bad hearing in one ear, you can't possibly localize, and that's the ball game. The NFPA decided what is an automatic disqualification, and this is not an automatic disqualification. When you read Dr. Beecher, she treated it as an automatic disqualification because, in her opinion, without doing any testing, she decided he probably can't do this, and that's wrong.
Okay, Thank you, Mr. Gordon. Thank you, Ms. Paulson. Rodriguez versus Beal.
May it please the court. My name is Donna Cook. I'm with the law firm of Pillinger Miller Trallo. I represent the defendant appellant in this case, John P. Beal. This matter arises out of a car accident that occurred on West Montauk Highway while Mr. Beal was traveling eastbound. This is a two-way road with one lane of moving traffic in each direction. The accident occurred in close proximity to an intersection with a roadway by the name of Captain's Way. It's respectfully submitted that the lower court's decision should be reversed, granting summary judgment on liability for the plaintiff. A non-negligent explanation has been provided and set forth by Mr. Beal as to the reasoning for this motor vehicle accident, a rear-end motor vehicle accident. Sun glare is his explanation.
Which direction was he traveling in, counsel?
He was traveling in the direction of eastbound at the time.
And that's where the sun rises?
And what time was he traveling?
The accident occurred around 6 a.m.
So that would, and that was in the
That'd be
suburbs.
unexpected.
Right? So the sun is rising. He's traveling east. He never heard of sunglasses?
Your Honor, the emergency situation which Mr. Beal was confronted with was sudden and unexpected. The standard for an emergency exception is not foreseeable. It's whether it is sudden and unexpected. And in this case, he was suddenly and unexpectedly confronted with the sun glare. In response, he immediately tried to slow down his vehicle, but unfortunately, he failed to see the garbage truck. The garbage truck, as can be seen specifically on page 27 of the record, is depicted by the police officer who did the report and arrived at the scene where the vehicles were placed, shows that the garbage truck was in the moving lane of traffic, eastbound, the single lane that Mr. Beal had control over for his direction of travel. And he also adds, Mr. Beal, in his affidavit that the garbage truck was 4 to 5 feet within his lane of traffic. The lower court fails to consider any of the negligent acts or omissions by the garbage truck in this action. And in fact, the lower court only focuses on whether or not Mr. Beal was following at a reasonable distance behind the garbage truck, which there are no facts to support that Mr. Beal was even following the garbage truck. There is a intersection close by to where the accident occurred, Captain's Way. It is quite possible, and because this motion was made before discovery, that this garbage truck entered the roadway of Montauk Highway just moments before the accident, and therefore it would be impossible for Mr. Beal to have been following at a reasonable distance.
You know what I really don't understand is how, as Judge Mendez brought out, you're traveling at 6 a.m. You're traveling east on a road, so the sun is coming up. How isn't that just an ordinary circumstance of the sun rising and then he gets glare in his eyes? How does that on these facts constitute an emergency?
Okay. Under these facts, the reason it would be an emergency is because he was suddenly and unexpectedly confronted with it. It's not something he would have been expected to foresee.
How is it sudden and unexpected? How is it sudden and unexpected? It's not unexpected that the sun shines at that hour. It just, you either know you wake up, it's raining, likely it won't be sun glare. It's sunny, you're driving east. If you make a turn, you need to be aware of it. It's just a caution that one has to take into account. It's like when traffic is speeding and it slows down or it stops. There's little excuse for hitting someone in the rear under those circumstances. It's something that has to be anticipated. Where is the sudden surprise here? The surprise particularly.
Well, Mr. Beal's affidavit indicates that he was suddenly confronted with this tremendous sun glare. He did not expect it to occur. Obviously, he had been traveling.
He's not aware of sun rising. He's not aware of sort of things that we learn as kids. Sun rises. If you're traveling east, you're going to have sun in your eyes. I mean, isn't that sort of ordinary circumstances?
Well, to distinguish this case from other cases that do find sun glare not an emergency exception, in this case, there's no evidence in the record to show that he was familiar with the roadway, that he should have anticipated that the sun was going to be in his foreview, and he did the best he could under the circumstances by slowing his vehicle and moving his vehicle towards the center line to give himself some kind of guidance. He was blinded by this light.
Thank you, Ms. Cook.
May it please the court, Alex Walwick for the plaintiff respondent. Your Honor, the critical point in this case is that the defendant doesn't say why he was suddenly confronted with sun glare. He just simply says, and my adversary keeps repeating that he was suddenly confronted with sun glare, but he doesn't say why. And as a question of familiarity, the defendant is the person in charge of all the knowledge and information that would make this an explainable rear-end collision case, which is what it is. It's an unexplained rear-end collision case with a stopped, very, very large, apparently garbage truck. And unfortunately, the plaintiff was in the back loading garbage into the truck. There's no question that it was stopped. It's not enough to say, as this court held in the Johnson versus Phillips case, to create an emergency, that I was confronted with sun glare. And in the Lifson case, the Court of Appeals said they granted summary judgment in that case, saying that there was no emergency where the defendant was about to turn to the west at a time of day that the sun would be setting. So he doesn't say, I was not familiar with the road. This was the first time I was on it. And that would be necessary at least to maybe create some sort of question of fact. But as Your Honors have pointed out, he knew which direction he was going. And as the Court of Appeals said in the Lifson case, we're expected to know which way the sun rises and sets, and to be prepared to be confronted by sun glare, apart from the fact that the defendant doesn't say in his affidavit how fast he was going. He doesn't say how far away he was from the truck when the sun glare confronted him. He doesn't say what distance he was from the truck when the sun glare confronted. These are all facts that the defendant alone would have possession of. Therefore, summary judgment here was properly granted. The court rejected the argument that this was a premature motion for summary judgment because obviously, as I just stated, all the facts are in the possession of the defendant and there's no point for further discovery. And I'll rest on my brief.
Thank you, Mr.
Thank you.
Okay, I'll give you 1 minute, Ms. Cook.
Yes. To distinguish the case law that was cited by the respondent, the difference between that case and this case is that particular vehicle and driver was turning into the path of the sun that was rising. In this case, Mr. Beal was continuously driving along Montauk Highway when the accident occurred.
It seems to me that he'd be more likely aware that the sun is in his face and that there's glare and he better be careful on the roadway.
But in these circumstances, he was confronted with it unexpectedly. There are things along the roadway which could have been casting shadows and preventing the sun from blinding him before that point.
Well, I'm sorry, is that in his affidavit?
Houses.
Is that in his affidavit about these other things that were blinding him?
No, that I'm suggesting that those are other things that would have been casting shadows and preventing the sun from blinding him up until the point that he did become blinded.
Okay.
Thank you.
Thank you, Ms. Cook. Okay, this concludes virtual oral arguments at the Appellate Division First Department. The court is now in recess.